Cell Towers. Her case.
It should be there. Let me double check and be right with you, everybody.
It's live now.
Cell Towers. Her case.
It should be here.
Files. 3 files. One is the draft.
Yes.
Everyone hear me? It's live now.
Yes, thank you.
No problem.
Here's Higgins, here's Towers. You know what I'm doing. Towers right here.
Okay, great. All right, I have it. Okay, we ready?
Yes,
Okay, we'll start with docket number 2020 DMOEB-05. Okay, please take notice that the municipal officers electoral board for the village of Dolton for the hearing and the passing upon objections to the nomination papers of Charles Higgins, candidate for the village trustee, will hold a meeting today, which is required by law to meet and pass upon objections nomination papers of candidates in the village of Dolton to be voted for at the consolidated primary election to be held on February 23, 2021. The board shall convene Monday, which is today at 12:30. Let the record reflect what time it is, Madam Clerk.
12:39.
It's 12:39 in the Village Hall of Village of Dolton at 14122 King Drive via remote Zoom conference for the purpose of hearing and passing upon objections to the nomination papers of Charles Higgins, candidate for the village trustee for February 23rd, 2021. Madam Clerk, will you take the roll?
Chairman Rogers,
I'm here.
Clerk Dugan here, Trustee Henry,
Present.
All members of the board are here.
yes.
And what attorneys are present?
Dennis Giannopoulos, present and appearing on behalf of the respondent candidate, Charles Higgins.
And Tiffany Nelson Jaworski appearing on behalf of the objector, Kiana L. Belcher.
And Ms. Samuels?
Amber Samuelson on behalf of the electoral board.
Okay, thank you. Okay, is there any public comment? Giovanni?
Not at this time.
Okay, I'd like to call docket number 2020 DMOEB-05, docket Belcher versus Higgins. Proceedings on the motion to disqualify. Rulings on the motion to disqualify, adoption of rules of procedure, further proceedings, if any, on motions, objections, and or arguments, and then a recess to another date to specify.
Mayor Rogers,
Yes.
if I may interject, I would suggest passing the rules of procedure prior to the hearing on the motion to disqualify, just because that under the law, we should have done that the first day. So.
Is there any objections to that?
No objection.
No objection on behalf of the candidate.
Okay. Do we need to actually read the rules of procedure?
I can give as I did in the previous hearings, I can give a brief overview, and then you would call for a motion to pass them.
Okay.
Okay, would you like me to do so?
I have no objection to that. Is any objections from anyone else?
No objection.
No objection.
As I stated in the previous hearings, the rules of procedure are the standard rules which were adopted by Cook County and the city of Chicago. These are the same rules that have been used previously in electoral board hearings. The one difference is that due to the pandemic, section 2A was added to deal with the issue of remote hearings, etc. Other than that, the rules are the standard rules. And I believe everybody has at this point received a copy.
I have.
Candidate has a copy.
Copy acknowledged. Tiffany Nelson Jaworski on behalf of the objector.
Okay. As stated and explained at the prior hearing in this matter, I am Riley Rogers. I'm the chairperson of the electoral board. Also serving on the electoral board is village clerk Mary Kay Dugan and senior trustee Tiffany Henry. These members are provided by the Illinois Election Code, which mandates our service to hear and pass upon objections filed against candidates' nomination papers. And we have a quorum. Okay.
I believe we need a motion on the adoption of the rules of procedure.
That is right. Okay, can I get a motion on adoption of the rules?
So moved.
I'll second that.
On the motion, Chair Rogers.
Aye.
Trustee Dugan. Clerk Dugan, aye. Trustee Henry.
Aye.
Motion passed. Okay, where do we start?
I think the next thing on is to just give a recap of the case status and filings. If you,
Okay, a recap of the case status and filings. Initial hearing was held on December 15, 2020. Case management order was issued subsequent to thereto. Second, the objector filed a motion to disqualify on December 16, 2020. The candidate filed a response to the motion to disqualify on December 18, 2020. The objector filed a motion for subpoena on December 16, 2020. The candidate filed an objection to the objector's request for a subpoena on December 17, 2020. The objector filed a response to the objection on December 18, 2020. In proceeding on to the motion to disqualify, oral arguments are on a motion. Objector's going to argue first?
Yes, I'm ready to argue. Are we ready?
Yes, we're ready.
Okay, great. Thank you very much, board members. We are here today in response or for a ruling on my client's request to disqualify certain board members from the electoral board. The objector recognizes, of course, that the Illinois Election Code provides that under statute, there are certain members of the electoral board that are, again, statutory members of the electoral board. Generally, for municipality, those are the mayor, the clerk, and the longest sitting alderman or trustee. If one of those is running for the office for which objections is sought, that person is disqualified by statute and then replaced with the second longest sitting trustee or alderman to move into their place. If that person is unavailable or unable to serve for some reason, then it goes to a public member. As we sit here today, we do not have a situation where there is per se statutory disqualification as it relates to somebody running for that same office. Instead, what we have today is a different type of disqualification that is sought. And this is a disqualification based upon a conflict of interest. The case law has been fairly clear that while you cannot remove somebody from an electoral board just for political bias alone, you can remove them from an electoral board, and they in fact should be removed from an electoral board if there is a pecuniary interest, and if they have a pecuniary interest in the outcome of the case, and in addition to that, where they may be called to potentially testify in a case. That's the Girat v. Keith case. So in this case right here, what we have here, we do not have a Gerard v. Keith fact pattern, that was a situation in which the clerk was going to be called to testify as to something related to the filing. So we don't have that here. What we have here instead is we have a pecuniary interest. Filed with our response, filed with our motion for disqualification, we filed an exhibit, 2 exhibits actually. The first exhibit is a screenshot of a campaign poster, I believe it is, or a campaign billboard that states paid for funds or paid for Riley's friends. When you look up Riley's friends on the Illinois State Board of Elections website, it's linked to Riley Rogers, the current sitting mayor and candidate for mayor of the village of Dolton. Also, when you look at the exhibit that was submitted as Exhibit A, you see on that exhibit that Riley Rogers appears on this campaign flyer, also with Gail Towers and Charles Higgins. Again, we understand that political affiliation alone is not enough to disqualify somebody from serving as an electoral board member. However, this is more than political affiliation. These flyers cost money. These campaign posters cost money. These billboards cost money. Clearly, we have a commingling of financial ties, and there is pecuniary interest that Member Rogers and Member Dugan both have in relation to keeping these 2 individuals. In this specific case, we're talking about Charles Higgins, but in the next case where we have the exact same issue, I'll be likely adopting the exact same arguments. So for the sake of judicial economy, I'll make the majority of my arguments here. These 2 candidates clearly, these 2 board members, specifically Member Dugan and Member Rogers, clearly have a pecuniary interest in making sure that Gail Towers and Charles Higgins stay on the ballot. They have, in fact, Riley's Friends is supporting all of these candidates. So there's that. And again, that is tied to Mr. Riley Rogers, the current candidate for mayor and the chairman of this board. And in addition to that, I mean, it's clear that they are all running together. Again, this is more than just political affiliation, though. This has to do with a financial interest. They're quite obviously fundraising together. They're going out there collecting signatures together, and they're going out there and putting up billboards together. And obviously Riley's Friends is paying for billboards to advertise this slate of candidates. So there is a pecuniary interest, and therefore it is our opinion that neither Member Dugan nor Member Rogers, because of this pecuniary interest, would be able to be an impartial judge, and we are asking for their removal from the electoral board and replacement with either the next available trustee in accordance with the statute or public members. Thank you.
Does the board wish me to proceed on behalf of the candidate?
Yes.
Okay. Good afternoon, members of the board. The issue that's before the board is on the objector's motion or petition to disqualify. And there's an allegation of commingling, things of that nature. However, there's nothing in the record whatsoever to establish that argument. There's no facts on that which is predicated. What you have is attached to the objector's motion to disqualify is you have a classic example of a political alliance. There appears to be a billboard shown, "Keep Dolton moving forward, vote Democrat, February 23rd," and it lists 5 individuals who have formed a political alliance seeking to be elected, nominated at the February 23rd primary election. That snapshot of that billboard appears on a Facebook page of Riley Rogers, and that's the record before the board supporting their contention that disqualification is appropriate. There's been no reference to the Illinois Appellate Court decision of Ryan versus Landeck, an appellate court case which squarely addressed the issue That's at 159 Illap 3rd at 10. And before the board, before the court in the Ryan versus Landeck case was essentially what this board has before it, and that is a political alliance which is alleged to merit disqualification. The Illinois Appellate Court recognized in Landeck, and I'll quote the language, referring to a case called Cook. Cook is analogous to the instant case. Similar to Cook, Ryan alleges he cannot receive a fair hearing because of political bias. Even if we assume these allegations to be true, we agree with Cook that the election code does not provide for substitution when an objector alleges political bias. It goes on to state that the legislature has set up a stable mechanism for addressing pre-election grievances. The statutory provisions allowing substitution under particular circumstances and judicial review adequately ensure an objector a fair hearing. It is not the province of the courts to inject provisions not found in the statute. Section 10-9 of the Election Code contains the provision which allows for statutory disqualification. Counsel for the objector correctly states that that has been found to include other situations such as in jurat, where a clerk might be testifying in the matter, then there's a requirement for disqualification. What we have before the board here is an allegation of commingling, yet you'll notice that there was no argument whatsoever that indicated the source of payment, the collection of a joint war chest. I believe there was a characterization that it was quite obvious, and I believe it's nothing further from the truth. The only matters before this board is a picture of a billboard with 5 individuals forming a political alliance, and at the bottom of the billboard, I believe my eyes aren't what they used to be, but I believe it's Friends of Riley Rogers. That's a classic case of political affiliation, a political piece, albeit a big one, a billboard, but a political piece listing the candidates in which there's an alliance at hand, and nothing more than that. In petitioners, or in the objector's objection, motion to disqualify, there's cited, apparently it's been abandoned at the present time, but there's a reference to the Ochoa case, which was a circuit court decision, circuit court order addressing a disqualification. And as noted in the candidate's response to the motion to disqualify, there are compelling facts put forward in the Ochoa decision, where the circuit court made specific factual findings that included that all 3 running for re-election jointly contribute and raise campaign funds and financing in a group known as the Cicero Voters Alliance. Here, there's been no suggestion, no evidence certainly put forward of the 3 running jointly contributing to the campaign piece, raising campaign funds. There's allegations, there's assertions, but it's not supported factually by any information whatsoever. Again, it's a raising of a political alliance and an attempt to bootstrap the disqualification on some means other than political alliance. Ryan versus Landeck teaches that political alliance is not a basis for this board member to disqualify itself. There are other facts set forth in the Ochoa case that were spelled out, that were solicited, and there were factual findings made by the court warranting disqualification. I'd like the board to take note, this issue isn't one of first impression. There's General Order 21 in the Circuit Court of Cook County. These are orders put out regulating court proceedings, and there's one rule, General Order 21, that specifically addresses electoral boards and contains a specific provision to address the matter before the board. And it does provide in Rule 5B that members of an electoral board must be disqualified on due process grounds if they have a personal or direct pecuniary interest in the outcome of a case, or if one of the members would properly be called as a necessary witness in a case, and therefore required to judge his or her own testimony. However, electoral board members do not have a disqualifying interest because they may be political allies or opponents of a party in a case, or merely because they're familiar with facts of a case. Neither may a statutory member cause a vacancy to be filled by this general order by a personal preference or convenience of that statutory member not to sit, or merely because a party has requested such disqualification. That's where we're at, I submit to the board. A party has requested disqualification, not on a statutory basis, with no facts sufficient to come anywhere near the compelling facts of Ochoa, but merely has made an assertion of campaign contributions with nothing whatsoever in the record to support it. I submit to the members of the board that the objector has failed to state a sufficient basis that not only would allow or require the board members to recuse themselves, but pursuant to Rule 5, Section 5B of General Order 21, I submit that the statutory member cannot sit merely because a party has requested the disqualification. So the mere request before this board with nothing more other than a request is not a sufficient basis for this board or the individual board members to shirk their statutory responsibilities. Thank you.
And may I have a couple minutes for reply?
Certainly.
Thank you. Just in reply, the objector has not abandoned the Ochoa arguments, and they were basically stated in a summary fashion so as to not belabor the point by stating that there is, in fact, a direct personal and or personal or direct pecuniary interest. In the Ochoa case, which interestingly, I was one of the public members that was appointed after the judge determined that public members were needed. In the Ochoa case, there were financial ties between the parties. The financial ties were certainly clear. Here, in my opinion, the financial ties are also certainly clear. We've got a billboard paid for by Friends of Riley Rogers, and that billboard is advertising candidates that are both on this electoral board as well as are being objected to. This is more than just mere political alliance. A political alliance is, a meeting of the minds, possibly formal agreements that you are going to act in a certain manner, formal agreements that, you're going to maybe come to somebody's campaign event. Putting somebody on a flyer, especially on a billboard, which we all know costs a pretty good amount of money, putting somebody on a billboard saying that you are supporting them with your name on there, with the statement of friends paid for by friends of Riley's friends, going that far takes it outside of the realm of just a mere political alliance and mere political ties. We can see that you cannot just remove somebody from an electoral board based upon mere political ties. And this is certainly the first step in our request. And, we may have to go before the circuit court to get this heard. So we are requesting that the board members at issue be disqualified because they do in fact have a pecuniary interest in the outcome of this case. Their running mates, which were all paid for by friends of, where their political literature has all been paid for by Riley's friends. Their political fate is tied to this case. And as such, because there is this pecuniary interest, this expenditure of money, that's what makes us different. In Ryan versus Landak, there was not the fact pattern that we have here. There was not the expenditure of funds. In some of the other case cited, there was not the expenditure of funds. Here we have the expenditure of funds. That's where the differentiation lies. And with that, I ask for a ruling to disqualify the 2 board members at issue. And I also rest on the additional arguments stated in my brief. Thank you.
Okay, is there any further rebuttal to that, Attorney Giannopoulos?
Nothing further. I'll stand on the argument and the submissions in my brief.
Okay. All right, Board Attorney.
I think first, you're supposed to have electoral board deliberations, if any.
Yeah, I mean, is there any response for any of the board members?
Yes, of course. Trustee Henyard, my response is I totally agree with Attorney Tiffany Nelson. I think that you two should recuse yourself and remove yourself from the board. I think you guys will be biased if you do sit on the board to hear the cases of Higgins and Towers, which are 2 trustees that's running with you and Clerk Dugan on this upcoming mayoral race. I will pray that you guys would do that and not sit here. This is unbelievable that you guys can even judge yourselves for staying on the board. I don't want a repeat of 2017 when Andrew Holmes came in and you was his judge, juror, executor as well, mayor, along with Clerk Dugan, to remove him from the ballot. I don't want that to happen again and the person stays on the ballot and have issues. So I'm praying that you guys would take heed to that and have some type of conscience and recuse yourself and remove yourself from this board and let a public member or the next trustee sit on the board. Thank you.
Board Member Dugan, do you have any response?
Only that I appreciate the distinction between having a political bias, which I think if that was the disqualifier, all of the elected officials who are running for offices have clearly made their preferences known to candidates. Trustee Henyard, by your own conduct, you accompanied the objector to file her objections. So clearly you share a preference as well for certain other candidates. So the issue comes to whether or not there's a financial pecuniary interest asserted that would disqualify us. And I have not heard one and I'm not aware of one.
Okay, with that being said, I think it is. You guys are spending money together. And if you guys had a problem with me sitting on the board, you could have challenged that as well, but you guys did not. So here we are. So
Right.
you guys must wanted me to
Bias.
sit here. Hold on 1 second. You guys must wanted me to stay on the board because you didn't challenge it, because you could have easily removed me. And if you guys will remove yourself, I'm willing to remove myself too. That way it will be fair. I have no issue with that. My issue is it being a fair ruling on the case. I don't want it to be biased and you guys are not going to remove your candidate from this board. You're going to put them on the ballot like you guys did in 2017 with Andrew Holmes. So that's why I'm speaking again now, like I did last time, to remove yourselves from this electoral board so that the person will at least have a fair shot. So if you guys willing to, I am too. So what are we going to do?
My point was that if bias was the only issue, then the elected officials would be required to remove themselves from considering all of the objections for all of the candidates because it applies in every single case. But the issue, as I understand it, presented by both counsel, is not who each of us supports or does not support, but whether or not there's a financial conflict of interest. And I have not heard one, and I am not aware of one.
Well, just like I thought. So you're not gonna, are you willing to remove yourself, Mary Kay? Are you?
From what I understand, absent financial conflict of interest, I'm not permitted to.
So that means no. Okay. So Mayor, you staying on the board too?
Trustee Henyard, I'm not sure whether your prayers are going to be answered today, but I am not removing myself from the board. I am the electoral board chairperson, and I stand at that.
Okay. And that's fine. So I just made my points for the record on how I felt about it. For residents or anyone that's watching, we had the same issue in 2017 when Andrew Holmes ran for office, did not live in town. The mayor basically approved him to stay on the ballot. Mary Kay Dugan, the clerk, approved him to stay on the ballot. Myself, trustee Henyard, voted no to take him off the ballot. So here we are with the same situation that we had in 2017. So I guess we will be moving forward and you guys will hear the case, but I want you guys to open your eyes, pay attention to what's going on in Dolton. Thank you.
I don't think there's any validity to what happened in 2017 in regards to what's going on today. I asked that the village, the electoral board attorney make a recommendation for the electoral board and we move forward to vote.
Okay, I think that having a political alliance isn't sufficient to qualify a board member for disqualification. That the objector would need to find some sort of financial ties between the parties, a pooling of finances, etc. And in my opinion, the objector has not met this threshold. Thank you.
Okay. At this time, I think it would be appropriate for the electoral board to vote on the motion to disqualify.
We need the motion, Mayor.
I'd like to make a motion to
Disqualify yourself.
disqualify myself as a board member in regards to this hearing.
Second.
Okay, it's been motion, it's been
Can I get a
seconded.
Point of clarification on the second.
Go ahead.
I heard that the motion, as I understood it, was that you disqualify yourself. Is that correct?
It was.
Right.
Okay. All right. Thank you.
Okay.
I don't know if that's the correct motion. Wouldn't it be a motion on objectors, or a motion for a vote on objectors motion to disqualify would be the correct language?
That's my understanding. The motion is to either grant or deny the objector's motion to disqualify.
Which
Yeah.
it could also be granted or denied in part. So if the mayor, if Mayor Riley Rogers' intention is to disqualify himself and remove himself from the board, then it would be a motion to accept to approve the motion, or to grant the motion in part and deny the motion in part. So I guess I'm just a little confused with what's going on.
I am as well.
Yes, I think that Mayor, we need to clarify the language of your motion so that way it's clear for the record.
Okay. And I modified that based upon what Madam Clerk had indicated. So to make it very clear, I'd like to make a motion to remain an electoral board member. Is that clear enough?
It was clear the first time, but go ahead.
Is this a motion on yourself, Mayor, or for both?
For
Objection.
both.
Okay, so it's a motion to deny objector's motion to disqualify.
Is that clear enough for everyone?
Yeah, well, Clerk Dugan's statement of the motion, I believe, expresses the intent of the board members through the discussion thus far.
Ms.
Okay,
Nelson?
So
Ms. Nelson?
I'll try it one more time, just so I'm clear as well. Mayor Rogers, effectively, your motion is to deny objector's motion to disqualify yourself and myself.
Is
In
that
other
clear
words,
for everyone?
Remain on the board.
Yes, that's clear. Thank you. Thank you, Mayor.
Okay,
Glad you got it. Okay.
okay. Is there a second? There was a second then. Is that, is your second the same, Trustee Henry?
it is not. No, it's not.
Okay, so
Okay.
you're not seconding it?
No.
You're not going to second?
No.
Okay. Madam Clerk, you want to second this?
No, I do not.
No, you do not?
No, I do not. I will.
Okay. For all clarification, so that this is clear for the interpretation of the vote, you are going to second.
I second the motion to deny objector's motion to disqualify Riley Rogers and Mary Kay Duty.
Is that clear enough for everyone?
Which would be with that we would remain on the electoral board.
That's clear.
Is that clear with everyone?
Yes.
Ms.
Yes.
Nelson? Okay. All right. There's a motion, and I'm not going to repeat it since it's clear to everyone. And there's a second on the floor. So why don't we take the vote?
Okay, one more time on the motion to deny objectors, motion to disqualify, Chairman Rogers. Knew that would trip you up.
I'm going to, got me confused now.
Yeah, go ahead.
Okay, to make it clear, however we're voting here, I'm voting to stay on the board. So you can we'll put it down. It's
Got it.
exactly the way it
Oh,
should
you
be.
want to say aye?
You can say aye to denying objectors motion.
Aye. Okay.
I will say aye as well. Trustee Henyard?
No.
Okay. Motion passed.
Um,
Motion passed, 2 ayes. Okay,
Okay.
I'd like a motion to have a recess for another date.
Oh, wait, I think we still have a couple matters that maybe some housekeeping matters. Attorney
Yeah.
Samuelson, I know that there was, we had filed some requests for subpoenas. And I believe that in the other cases where Mr. Giannopoulos is working with the candidates, there were some objections filed. I wasn't sure if he was planning on doing the same, if he was planning on filing a motion to dismiss on those. So I think there might be some more briefing schedules, things that may need to happen. So I just wanted to bring that up.
And because we stopped so abruptly on this case and on the Towers case, we didn't get through the full agenda from the last meeting. So we're actually going to go back to the, I would ask that we go back to where we left off in the last meeting, confirming appearances, entry of the exhibits, a summary of the issues, and then we can move on to discussion on those subpoenas, just so that way we've done everything on this case that we did on the other case as well.
Works for me.
Okay.
Makes sense. Makes sense.
Okay. I missed that.
So we're going back to, it would be introduction of the parties and the filing of appearance.
Okay.
If you're looking for an introduction, Dennis Giannopoulos appearing on behalf of the respondent candidate, or the candidate, Charles Higgins.
And Tiffany Nelson Jaworski, I can't even talk, I'm sorry. Tiffany Nelson Jaworski appearing on behalf of the objector.
Okay. And I can confirm that both parties have filed appearances. And they have already confirmed that they have also received copies of the rules of procedure.
Right.
Yes.
That's correct.
And so then next would be the introduction, labeling, and entry of electoral board exhibits. Mayor, would you like me to read the electoral board exhibits into the record?
If you could.
Okay. Exhibit number 1 is the objector's petition. Exhibit number 2 are the candidate's nomination papers. Exhibit number 3 is the call of the electoral board. Exhibit number 5 is the agenda for the first initial hearing, which took place on December 15, 2020. Exhibit number 5 are the proofs of service, waivers of service, and appearances filed by the parties in the applicable electoral board case. Exhibit number 6 is the rules of procedure. Exhibit number 7 are the proofs of service and waivers of service filed by the board members. And then we would need a motion to accept the electoral board's exhibits into evidence.
So moved.
Second.
Motion to accept the exhibits into evidence. Chairman Rogers.
Aye.
Clerk Dugan, aye. Trustee Henyard.
Aye.
Motion passed. All 3 ayes. Okay, exhibit number 2.
Sorry, Mayor.
Yes, okay.
1 through 7, Mayor.
Are we accepting all of these?
Yes,
Yes.
that was my motion.
All right, good, okay. Summary of issues. Request for objectors, attorneys to provide summary of issues raised and whether they are purely legal or if they are factual matters to be determined, and whether a records examination will be needed.
Okay. So if I may, again, Tiffany Nelson Jaworski on behalf of the objector. The objections to Charles Higgins relate mostly to relate entirely to the use of his name and what his correct name is, and the voter confusion that follows thereafter because of him not using the correct name. So at the address that the candidate is registered to vote, there are two Charles Higgins. There's Charles B. Higgins and Charles H. Higgins. The nominating petitions simply state Charles Higgins. They do not delineate or differentiate between Charles H. Higgins and Charles B. Higgins. When those petitions were circulated, the voters could not and would not know whether it was Charles B. Higgins or Charles H. Higgins who was running for office. Maybe they really like Charles B. Higgins, but can't stand Charles H. Higgins. But they signed the petition because they thought it was Charles B. rather than Charles H. Or vice versa. Maybe they think Charles H. is highly qualified for office, but that Charles B. would not be qualified whatsoever. And as such, it's situations like this where there is a substantial basis for voter confusion, because you have two people with the exact same name, with the only differentiation being between the two names being the middle initial, omitting that middle initial. The question then arises, was that a mistake or was that a purposeful thing? Was that an attempt to get more signatures based upon some people might possibly like Charles H, or some people might possibly like Charles B and think that that person is qualified? There's clearly a potential for voter confusion as it relates to the face of the petitions, as well as the rest of the nomination papers. And because of that voter confusion, these nomination papers of specifically of Charles Higgins, whether it's Charles H. Higgins or Charles B. Higgins, we still don't know. Nobody knows at this point whether those nomination petitions were correct, whether those nomination papers were correct, and his name should be stricken from the ballot, as he did not fully state his name. Thank you.
You're on mute.
Is there any rebuttal to that?
Yes, Dennis Giannopoulos on behalf of the candidate. The assertion that the names of Charles Higgins create some form of voter confusion, or that there's two Charles Higgins living at the address, and this boils down effectively to a legal issue. But I'd like to clarify, just for the record, that there's only one Charles Higgins living at the address, and that is Charles B. Higgins, whose certified voter registration records show him to be Charles B. Higgins, who is the candidate, and Charles H. Higgins Jr. So there is a Charles Higgins Jr., not the candidate, and a Charles Higgins, the candidate, who correctly listed his name as Charles Higgins. So to the extent that we can obviate the issue with the subpoena, I'll stipulate to the fact that Charles Higgins is Charles B. Higgins. Once that determination is made, then we move on to a legal issue, and the legal issue, quite frankly, is whether or not it is fatal not to list a middle initial. And I would cite to the board, when the time is appropriate, the express provisions of the Illinois Municipal Code, or I'm sorry, the Illinois Election Code, which specifically addresses the issue of middle initials, juniors, seniors, and the like, indicating that there is no mandatory requirement whatsoever of the election code differentiating or requiring someone to use a middle initial or omit a middle initial. I believe this issue can be squarely addressed on a legal basis, and perhaps by stipulation, avoid the request for the subpoena currently pending for such things as income tax records. Income tax records over a middle initial? I don't believe there's any basis for securing or seeking such records. But we can address that as subsequently.
If I may, just briefly in reply, I also have the certified voter registration records for the address on the petitions, which is 14322 Irving Avenue. I have those on my computer screen. I can share those if you'd like. Does anybody have any objection to me sharing them on the screen?
No, I
how personal-
displayed. I'm sorry.
How personal is it?
Well, it's got their address and it's got their certification number.
I have no objection, unless
I don't either.
his attorney,
Does the attorney for,
Mr. Higgins.
yes, do you have an objection?
We'll be showing a certificate of registration for 14322 Higgins, or Irving and Dolton.
Yeah, and it seems that I'm not able to screen share right now. So, I'll just go over it and I'll just tell everybody kind of what's going on. I mean, because obviously, we may be briefing this, and this is just sort of the introduction of the case. So registered to vote at that address are Kenneth Williams, Charles H. Higgins Jr., and Charles B. Higgins. So if council, I would agree to a stipulation, council, and I can speak off record or off the record, but I would be willing to agree to a stipulation that that's what the certified voter registration records state, and I can forward those to council and we can have that discussion. Council is correct that this is primarily a legal issue. I don't think that there's really any facts except for which Charles Higgins this is, because on the face of the petitions, you can't really tell which Charles Higgins this is. And I do agree that while the election code states that middle initials are not required, when you have a situation of people having the exact same name and there's a basis for voter confusion, there are certain things that need to be done to ensure the voter confusion doesn't ensue. And it's my opinion, as well as, so it's my opinion, and I think the opinion of many people, that in a situation like this, where you have somebody who has the exact same name, but the only differentiation, again, is a middle initial and maybe a junior at the end, a suffix at the end, that those things need to be placed on the nominating petitions so that the voters know, are we voting, are we signing up for senior or are we signing for junior? Again, some may think that senior should not be a trustee. Some may think that junior should not be a trustee, but the voter should be allowed to make that choice. And by only putting Charles Higgins and not Charles B. Higgins or Charles H. Higgins Jr., the voters were deprived of that choice. So that is the summary of my argument. I understand that there's potentially going to be some briefing, but if council is willing to stipulate to the certified voter results, which I'll send to him right now. I think they were included in my brief, but I will send those over to council and we can deal with that.
Would certainly be willing to stipulate public record. And again, I appreciate council's willingness to do so. That should obviate the need for the subpoena request that's pending, because with no factual matters in dispute, there would be no need to subpoena the records on an issue that's legally of legal concern only. And just briefly, and I appreciate council's opinion that certain information would be helpful or beneficial to the voters, but that's not the standard that this board is charged to deal with. It's a statutory interpretation of the provisions of the Illinois Election Code, not what a given individual happens to believe would be a better way to do it.
So if there's a stipulation, just a housekeeping matter, does that mean that the objector will withdraw their motion for subpoenas?
I will have to confer with my client to ensure that she is okay with that. So I would like to reserve that decision. If I can send an email later today
Okay.
regarding the subpoenas. But if we have this stipulation, probably, I just got to confer with her and make sure that she's okay with that.
Okay. So, Mr. Mayor.
I'm here.
Okay. Since there's a potential that the objector will withdraw their request for subpoenas, I would suggest that we move on to setting a schedule for any motion argument and possibly a date for any type of stipulation. Does the candidate's attorney have any objection to a date for which you issue a stipulation? Or you just want to stipulate on a record? Is that sufficient?
Well, council's not prepared to stipulate, but it appears the matter will be resolved by way of stipulation. I believe that to be the case, and I believe council does as well. And again, I apologize. Perhaps we should have had a pretrial discussion and have resolved this and had an agreed stipulation at the time of the hearing. So I apologize to the members of the board for not having done that.
Okay. So then I guess the next step would be to set a schedule for motions and arguments.
Yes.
Now, is this, and we're going forward just because the attorney has made a, I'm not sure if it was a suggestion or motion that we do away with the subpoenas?
It was a suggestion that you set those for whatever we decide our future date is, to set those subpoenas for hearing on our next date. And to instead, I think we would know our next date after we figure out the briefing schedule for any motions.
Right. Okay. Is there a suggested date?
I believe council, we're looking for a date on a briefing schedule for motions to strike and dismiss, I take it?
Yes.
Yes.
Okay. I could have my brief by 5 p.m. on Wednesday.
Okay. Any objections to that?
Mayor, what, you saying, so we doing something Wednesday? I'm trying to follow you guys.
So the candidate will be filing his preliminary motions on Wednesday, December 23rd at 5 p.m.
Oh, but it's no court.
Yeah,
just
it's not a hearing
Yeah.
date.
Oh,
Just-
okay, okay.
Don't worry, we won't be, we'll have until after the holiday, after at least the Christmas holiday.
Okay, sounds great.
I just wanted to interject really quickly. I did hear back from my client. We can in fact withdraw the request for subpoenas. So we'll just go forward based on the stipulation as to the certified records provided. Mr. Giannopoulos is okay with the certified registration records I just sent over to him. And then if I may, as it relates to a response to the motion to strike and dismiss, if I could have it maybe Monday at noon, or I guess when are we going to be reconvening? Because I obviously want to give the board enough time to read my briefs. We do have the holiday this week, which happy holidays to everybody.
How about February 24th?
That might be a little late. We usually don't get that long. But I appreciate you. So if there's no objection, Monday, the 28th, if I could have until maybe 1 p.m. so that way we have enough time the board has enough time to review it. I assume we'll probably meet again on Tuesday or Wednesday of that week, but it's.
Okay, what, this is for the court hearing, or you want to file your brief on that day?
Yeah, this is to file my response to Mr. Giannopoulos's motion to dismiss.
So, Mr. Giannopoulos, you will have yours ready this Wednesday by 5?
Yes.
Okay, anyway, is it Nelson or?
Nelson
What's the-
Jaworski. Yeah, I
Nelson
got married and had to take the husband's name. I told him to take mine. Nelson's much easier to spell, but he wouldn't listen.
Okay. Any relation to Ron Jaworski?
No, but you know what? I have a funny story where my husband used to joke around and tell people that he had Uncle Ronnie, that was his favorite uncle. So I did buy my husband a Ron Jaworski signed jersey to put in our basement. So.
Okay. Okay. But any rate, any way to speed that up a little bit? You know, we're coming up into the holidays. We're coming up into the New Year's Eve, to try to get this whole matter settled so we can get some ballot numbers and know who's on the ballot and things like that. And
Well, that's what I was gonna say. That's why I was asking for Monday. So, because obviously there's Christmas Eve and Christmas.
Right.
So I was really trying to hope to have a day
You
or
know,
two
If
that briefing.
we
on
can
those
get
days.
brief filed by
Wasn't
5
planning on
o'clock.
working on it over Saturday and Sunday.
Yeah.
Maybe if I can have Monday at 10 a.m. That way everybody will have it in their mailbox Monday morning.
No, I was gonna say, if we can get your brief file at the same time as Attorney Giannopoulos.
Oh, no, I can't.
no.
No, my brief is in response to his brief.
Okay.
So I
okay,
can't,
Okay,
I mean, Dennis and I have known each other for a long time and I can sometimes predict what he's thinking, but not like that.
yeah.
Council
All right.
need an opportunity to respond. Just you got to see what I put on the table before she can
Right.
respond to it.
Yes, yes,
All right.
okay. Or if you don't choose to respond, we can speed this up too, but
Well, I'll respond.
at any rate, we're approaching the holidays and we'd like to try to get all of this stuff squared away as quickly.
Yeah,
You know,
I completely appreciate the lightning fast pace we need to move this along.
Right.
So if I could just, I mean, because I just want to have time to brief it, proof it, and get it
Right.
all ready for you guys. So that's why I had originally suggested Monday at like noon or 1 o'clock. That way you guys still have it. You have half a business day to review it. Believe me, it's not going to be more than like 4 or 5 pages, I'm sure.
right. And then, if we were to eliminate the process of the subpoenas, that would shorten the process too here.
Well, we already have. I just put on the record that my client is okay with dismissing the request for subpoena. So I will withdraw on the record. I am withdrawing those requests for subpoenas. So
Right.
we are just solely dealing with the motion to strike and dismiss.
Great, okay.
So do we want to come back then on Tuesday, December 29th? Does that date work for everyone?
Bear with me for 1 second.
For a hearing on the motion, the anticipated motion to strike and dismiss?
Mr. Giannopoulos, would I give you enough time to review her response to your briefs?
That would give me enough time. I don't know what time is being contemplated, but I do have a physician's appointment at 10:30.
What time would work? What time do you think you would be available?
I believe that it would be sufficient if we could do it at say 1 o'clock.
Yeah.
Would
That
I
works
give
for
you-
me.
Would I give you enough time? Is the position close, proximity?
It's at rush, but they're usually pretty prompt about getting me in and out. So the 1 o'clock should be sufficient.
Okay. Does that work for everyone?
That works for me. I mean, I have the whole afternoon right now open for that. So Dennis, if you need to move it back even further, just to give yourself some cushion, I'm fine with that.
Maybe take it to 2 o'clock if that's convenient with everyone else.
That's
Yeah,
fine.
That's fine. I suggest that, yeah. Okay, great.
Okay, so just to recap the schedule for motions and arguments, and any preliminary motions will be due Wednesday, December 23rd, 2020 at 5 p.m. Responses will be due Monday, December 28th at 10 a.m. Hearing on arguments is December 29th, which is a Tuesday at 2 p.m. And I think we were doing a motion to accept the briefing schedule previously.
Yes, was there a motion on the floor? Madam Clerk, was it? No, okay.
No.
Why don't we make a motion to accept the briefing schedule as noted?
I'm gonna make a motion to accept the briefing schedule as noted.
Second it.
Vote, Chairman Rogers,
Aye.
Clerk Dugan, aye, Trustee Henyard,
Aye.
3 ayes.
Motion carries 3 ayes. Okay, now do we need a motion for the continuation of the hearing on the 29th?
29th at 2 p.m. Yes, you do.
Okay, I'd like to make a motion for a briefing hearing schedule, if you will, for the 29th, December 29th at 2 p.m.
Second.
Just the second by Trustee Henyard. Roll call.
On the continuance to the 29th. Chairman Rogers,
Aye.
Clerk Dugan, aye, Trustee Henyard,
Aye.
Motion carries. Now, can we adjourn this meeting and go into another next week?
I think what we should have done is motion to recess this board until. Actually, no, I don't know that we need that. I think we can just move on into the next hearing.
Yeah, it's
Yeah,
the
like-
same board, so.
It's
Okay,
the
I'd like
same
to take
board.
I'd like to take a 5-minute recess.
That's fine. Is that
Okay.
everyone?
Yeah, I got a question. We
Yes.
didn't set a date for the one we were just speaking about, right? For towers?
We're about to enter into towers. We haven't handled towers yet.
Okay, all right.
All right. So
Okay.
we could all come back in 5 minutes. So like 1:42,
Uh,
1:45. Does that work?
that
Okay.
works. 1:45. Recess to 1:45.
Okay.
All right.
Great, thanks. Okay, it's 1:45. Should we convene now? Is everybody on board?
Looks like everybody's starting to come back, so. Um,
Hey, Amber, it's Giovanni. I just want to make sure you've been able to see the message I sent.
yes, I can see the public comments.
Okay, just making sure.
I'm looking through them right now to see, because the public comment period was at the beginning of the last agenda. So I'm looking to see what public comments there are as they relate to candidate towers.
Okay.
is everybody on board yet? Are we ready?
Yes.
Okay, you done are you done reviewing the comments? Attorney Samuels?
Yes. What's the question?
I know you said you were reviewing, I thought, comments for the
Yes,
Towers case.
I have access to all of the comments. So when we get to the public comment portion of the agenda, I will read the ones that seem to be related to the motion to disqualify for Towers. Though I will say it seems that with the public comments, some more conversation between individuals than comments for the board. So.
Okay. All right, I'll just read the open meetings public notice, Open Meetings Act public notice. Is that necessary? Or we go right into roll call to order?
Oh, I'm sorry, what's the question?
Do I need to read the open meetings public notice, or can we go right into the roll call?
You should read the statement and findings of in-person meeting unfeasibility due to the COVID-19 pandemic.
Okay.
And then go into introduce yourself and then the roll call.
Right. Okay, this is Municipal Officers Electoral Board of the Village of Dolton. Continued Electoral Board hearing, December 21st, 2020. I am the chairperson, Riley Rogers, or the Electoral Board. Attorney, why don't you identify yourself?
Attorney Amber Samuelson.
Okay, great. Please be advised that on December 11th, 2020, the governor of the state of Illinois issued his latest statewide disaster proclamation related to continuing public health emergency executive orders implementing further enhanced mitigation measures and restrictions. As such, pursuant to Section 7E of the Illinois Open Meetings Act and the rules of procedure, and as chair of this board, I have determined that holding a meeting entirely in person that is otherwise conducted in full compliance with the Illinois Open Meeting Act is neither practical nor prudent because of the ongoing disaster. To the extent necessary, this meeting will be conducted with the option to participate via internet teleconference and without requiring the physical presence of a quorum. I further find that due to the disaster, the physical presence of more than 10 people at the regular meeting location in an accessible, hygienic, and legally compliant manner is not feasible. Alternative arrangements have been made to allow the public to contemporarily hear all discussion, testimony, and roll call votes via Zoom teleconference. All votes shall be conducted by a roll call vote, and a verbatim record of this meeting shall be made and maintained in accordance with the Open Meeting Act. All participants are hereby further notified that by participating at this meeting, they acknowledge and are informed of this meeting's public recording. Thank you. The introduction of the municipal officer for the Electoral Board. As stated and explained at the prior hearing in this matter, I am Riley Rogers, the chairperson of the Electoral Board. Also serving on the Electoral Board is the village clerk, Mary Kay Dugan, and the senior trustee, Tiffany Henry. These members are provided for by the Illinois Election Code, which mandates our service to hear and pass upon objections filed against candidates' nomination papers. Madam Clerk, will you take the roll, please?
Chairman Rogers?
Here.
Clerk Dugan here. Trustee Henyard? Trustee Henyard, are you here?
I'm here, present.
Okay. All right, we have a quorum established. The appearance of the attorneys. Can you confirm? Who's here on Zoom?
Tiffany Nelson-Jaworski on behalf of the objector, Kiana L. Belcher.
And Dennis Giannopoulos on behalf of the candidate, Gail Towers.
Okay, great. And Attorney Samuelson, you're here for the Electoral Board. You have announced yourself already.
Yes.
Okay. Is there any public comment?
There are two comments that have noted that their comments are for the board. The first public comment comes from Dwayne Mohammed. How can any member of the board make a decision of disqualifying candidates when money and political interests bind them. No running candidate should be on this electoral board. And then from Mike Smith, should all recuse yourself. And that's all that I have for comments to the board.
I have no answer for that.
Well, I answered that already. I said everyone should step down and everyone should remove themselves from the board and basically let it be public members or the next sitting trustees. I suggested that the mayor nor the clerk wanted to do so, and they wanted to stay on the board. So I answered that.
Thank you, trustee. Thank you, trustee Henry.
You're welcome.
Okay. That's all for the public comment.
That seems to be everything that was directed directly to the board related to the disqualifying of disqualification for trustee Towers, or related to the trustee Towers case. I apologize. Am I correct, Giovanni? She's still on?
Yes, I'm still here. You're accurate. Yes.
Okay.
All right, great. I'd like to move on. The adoption of the rules of procedure.
Okay.
Attorney
As I stated previously, the rules of procedure are the standard rules. They're the same rules that were adopted from Cook County and the city of Chicago. They've been used by this board many times. The biggest difference is that the rules of procedure do address the COVID-19 pandemic and the need to have hearings remotely via Zoom.
Okay, great. I'd like to make a motion to adopt the rules of procedure as presented.
Second.
She's been motioned and seconded to adopt the rules. Roll call, Madam Clerk.
Chairman Rogers?
Aye.
Clerk Dugan, aye. Trustee Henyard?
Aye.
Motion carried, 3 ayes. Okay, Madam, oh, I'm sorry, Attorney Samuelson, you want to go for it?
Sure. The next on the agenda is a recap of case status and filings. The initial hearing was held on December 15, 2020. Case management order was issued subsequent thereto. The objector filed a motion to disqualify on December 16, 2020. The candidate filed a response to the motion to disqualify on December 18, 2020. The objector filed a motion for a subpoena on December 16, 2020. The candidate filed an objection to the objector's request for subpoena on December 17, 2020. The objector filed a response to the objection on December 8, 2020. The next step is a proceeding on the motion to disqualify. Are we ready to have oral argument on the motion?
Attorney Jaworski.
Yes, sorry, I was trying to unmute myself. Yes, I think Mr. Giannopoulos and I can both agree to adopt the arguments that we made in Higgins over to this matter. I just wanted to briefly summarize what occurred in Higgins, and if anybody has any disagreement with what I'm summarizing, then we could do that if that's okay. I just wanted to basically state that we had argued as the objector that there is a pecuniary interest because of the campaign literature between the parties, that Clerk Dugan, Mayor Rogers should both recuse themselves from the electoral board as it relates to this case, because they are in fact not just running mates, but we have argued that the billboard that has all of their faces on it was paid for by Friends of Riley Rogers, and as such there is a pecuniary interest. But as stated, I will agree, if council agree, to just adopt the arguments that were made in Higgins because they are identical.
I would certainly have no objection to agreeing to that. I stand on the arguments raised in the preceding oral argument as well as the information contained in the written briefs.
And same here.
Okay. Is there any further deliberation from the electoral board?
Not me. Madam Clerk, any from you?
No.
Trustee Henry?
No.
All right, great.
You're gonna try that
Then
motion
I
again?
would ask- What was that?
Are you gonna try that motion again?
I was going to say, to simplify it, we're staying. At least I am. I'm not going to recluse myself from the hearing. So however you want to put it, Madam Clerk, so we can vote on it.
Well, in the prior case, the motion was to deny objector's motion to disqualify yourself and myself. And that was your motion and my second.
Yes.
So do you want to motion again
Um,
to deny the objector's motion to disqualify?
that's my motion.
Okay, and that's my second.
Okay, so Mayor, I do want to put my comments on record, which is the same as the last case Higgins. So I do feel that you two, meaning the clerk and Mayor Rogers, should recuse themselves and remove themselves from this electoral board. I do believe you two are biased in being the judge for your candidate who's running for trustee on your ticket. And I think you guys should not be allowed to judge them as it relates to them being on the ballot for 2021 February election. That's my statement. Thanks.
And I would like to clarify my earlier understanding, and correct me if I'm wrong, that absent of financial interest, pecuniary interest, bias alone is not even allowable grounds for disqualification. Is that a correct statement? As I understand the previous arguments?
Well,
Let's
I
see.
just feel you guys she's not gonna get a fair trial because you guys are going to allow her to stay on the ballot regardless of what the evidence states. So that's why I was stating it should consist of public members or the next trustees that have seniority on this board.
Well, the next trustee is also running for trustee. So my question or my statement before was, again, my understanding that if we're talking bias alone, that's not a ground to recuse, even permissible, even if we all wanted to do that. But if we all wanted to do that, and meaning all the candidates, all the current members of each and every board who are running for office, and replace all of the boards with public members, I personally would be very okay with that. But what I understand is that's not allowable.
How? If it's you are recusing yourself, you're saying, I, Mary Kay Dugan, don't want to sit on an electoral board. That's it. It's done. Then they pick a public member, which I could have sworn Attorney Tiffany Nelson stated when she read arguments earlier about replacing the board with public members if it's not a trustee. So that's just
in the matter, there's a financial interest. But as far as bias alone, which you keep returning to, Trustee Henyard, bias alone under the, and this is what I understand, and I'd be happy for the attorneys to clarify this. From what I understand from the Cook County Court rule, political support or opposition bias is not in itself grounds to recuse. In other words, we may not recuse ourselves even if we want to, absent a financial or pecuniary conflict.
I'll take the invitation from council to briefly address what I believe Member Dugan is referring to is the argument that I advanced and read, General Order 21, Section 5B of the Circuit Court of Cook County, which indicates that, again, and I'll quote, neither may a statutory member cause a vacancy to be filled by this general order by a personal preference or convenience, or that a statutory member not to sit merely because a party has requested such disqualification. The Rule 10.9 mandates the composition of electoral boards and provides limited, I don't want to get into argument again, but that's my understanding of what language the clerk was referring to.
Yes.
And if I just made one thing I wanted to point out, that does state that, you know, because of personal preference or convenience, that does not state that if the individual does not feel that they can provide an unbiased decision, then they can't. If somebody feels that they cannot hear a case unbiased and be unbiased, it's my belief that even with General Order 21, that they could then recuse themselves. But that's, you know, again, based upon that's not a personal preference or convenience, that's their own personal view that they cannot be unbiased.
For the record, I would agree that if the board members felt that they could not be fair and objective, and a recusal might be appropriate. But the issue of political bias being alleged is the issue that I was addressing.
Thank you.
Did we have a motion with a second on the table?
I believe I was waiting for Chairman Rogers to make the motion as he did the last time.
I just want to add to the previous discussion before I make the motion.
Okay.
I'd like to add to the previous discussion before I make the motion. First of all, I want to ask, is there a court reporter on board here? Okay, I didn't see her, or it was mentioned earlier. Secondly, I'd like to make the remark, since everybody's putting things on the record, that to mention the fact what Clerk Dugan had mentioned earlier in the previous case in regards when the objections were filed. You want to talk about relationships. Our senior trustee was with the objector when she filed the objections. And secondly, when you want to talk about billboards, there's a billboard appearing now on I-94 with the senior trustee and the person that filed the objections. So when you want to talk about unbiased opinions, can she not be unbiased? So moving forward, I just wanted to make those remarks for the record when you talk about relationships and financial interest. And certainly there was a financial interest to put a billboard, Attorney Jaworski, when you talk about financial interest and expense as far as much as what they cost and things like that. So there's an interest between a party that's on this board and a party that filed the objections. And I just wanted to make that clear and enter that into the record. Now I'd like to make a motion. The motion that
Okay, so hold on, Mayor. So no, I'm going to rebuttal. So
now
one second.
hold on.
You make the motion. Hold on, discussion. I can still say my part. I am a member as well.
Okay,
Come
go
on.
ahead. We'll listen.
So Mayor, if you feel, could you just put your foot in your mouth, that that's a financial issue having a billboard, then why aren't you recusing yourself? And if you guys wanted me off of this board, guess what you could have done? You could have easily put it up and said, I do not want Trustee Henyard to sit on the electoral board. You guys did no such thing, Mayor. So that's why I'm still on the board. So I also offered you guys of olive branches, said I would remove myself if you two remove yourself. You guys still decided not to do so and still want to sit on the board. So that tells me one thing, that you guys want to keep your candidate on the ballot, period, because we all can remove ourselves by verbally saying we're not going to sit on this board. We're going to go and seek out public members to sit on the electoral board as it relates to Gail Towers and Charles Higgins. But no one is saying that but Trustee Henyard. So stop it. Thank you.
And do you understand that you'd be willing to recuse yourself from all membership on all of the boards?
All what boards? I sit on this board. So if you want to remove yourself, let's go. We all can remove ourselves. I've been put that out
There
there.
are objections to
But
other.
no one is saying what I'm saying but me.
Hold. All right, you made your comment. Thank you. My comment was in regards to the objector's attorney when she brought up the fact about billboards. So I just wanted to enter into record that there still is a relationship between yourself and the objector that appears on the billboard. And when she brought up the fact about financial interest, the billboards are expensive and they have to be paid for. So I just wanted to get into that in the record as far as the relationship there.
Right, but what I'm
No,
saying is that you're agreeing with her. Basically, you're stating that that's a financial interest is what
we
you
heard
just
what you
stated.
said.
Hold
We
on,
heard-
that's what you
we-
just
we-
stated.
we
So if
heard-
that's the
we heard
case,
what
that
you
was
just
her
said.
argument. That's what she
Trustee,
said. You
trustee,
said the opposite. But as
trustee.
it relates to me, you're
Trustee.
agreeing with her. That's my point. If you're
Trustee.
agreeing with her, remove yourself,
Trustee.
Mayor. Mayor, look,
Trustee,
do you want to remove
we
yourself? So I
heard
can
your
remove
comment.
myself.
We heard your comment,
Mayor,
trustee.
do you want to
We
remove
heard your
yourself?
comment. We
Mayor,
heard
do
your
you want
comment.
to remove yourself? I will remove myself too. So
I'm
are you
asking-
willing to remove yourself, Mayor?
I'm asking order right now.
And
That's what I'm asking
and
right
this is
now on the
order.
board.
I had the floor.
I'm
Are
asking
you
order.
willing to remove yourself, Mayor? Because I am. Are you?
Madam Clerk,
I'm
go
fine
ahead.
with that.
Go ahead with the motion.
Right, that's the
Madam Clerk.
answer. Like I thought. We putting on our show for what? But you're not gonna do nothing. You gonna
Trustee,
keep saying what
you are
saying, but you're
out
not
of
gonna
order
remove
right now,
yourself.
trustee. You are
Because you're
out
not
of
gonna
order
remove
right now.
yourself, but you put on the show. Why?
You've made your comment.
For
You
the
are out of
record,
order
I'm
right
willing
now.
to remove myself, Trustee Tiffany Henier, from this electoral board.
You're
If
fine.
A, Riley Rogers remove himself, and B, Clerk Dugan remove herself from the board. That way, it will be unbiased, and we can
Attorney-
have a fair trial.
Attorney.
Yes.
There it is.
If I
I
may,
think there was a motion that had been made and seconded, so
Not
it
yet.
would be, not yet.
if I may,
Okay.
Trustee Henyard, are you including recusing yourself from hearing objections to the other trustee candidates and the clerk candidate?
Clerk Dugan, we talking about this one right now. Y'all ain't gave me an answer, so stop it. So
Okay.
is you gonna recuse
guess I
yourself
can
from
remove
this one, then I will. But on both of y'all, you both remove yourself, I will remove myself too. I don't have to sit on the board. I
Trustee
don't.
Henry, trustee Henry. Okay, that's not the motion on the floor.
Exactly.
Let's
So
move
why we
on.
talking about it?
Okay,
Y'all
fine.
ain't gonna do it.
Okay, I understand that would be a no. Okay. Mayor Rogers, have you made your motion to deny objectors' motion to disqualify?
Let's get this clarified again.
Yeah.
Okay,
Same as before.
okay.
Motion to deny the objector's motion to disqualify yourself and myself.
Aye.
So moved. Okay. I will second. Roll call. Chairman Rogers.
Aye.
Clerk Dugan, aye. Trustee Henyard.
Definitely not.
Okay. 2 ayes, 1 nay.
Okay, election attorney.
All right. Next are the proceedings on the objections to Belcher versus Towers 2020 DMOEB 07. And I would ask that because we didn't do this in the last hearing, I would ask that the parties introduce themselves and confirm that they have received a copy of the rules of procedure.
Yes, Tiffany Nelson Jaworski for the objector, and yes, I confirm we have in fact received a copy of the rules of procedure.
Dennis Giannopoulos on behalf of the candidate, and I acknowledge receipt of the rules of procedure as well.
Okay, and I will confirm that both parties have filed their appearances. And next would be the introduction, labeling, and entry of electoral board exhibits. Exhibit number 1 is the objector's petition. Exhibit number 2, candidates' nomination papers. Exhibit 3, the call of the electoral board. Exhibit 4, the agenda for the initial hearing. Exhibit 5, proofs of service, waivers of service, and appearances filed by the parties in the applicable electoral board case. Exhibit 6, the rules of procedure. And Exhibit 7, proofs of service, waivers of service filed by the board members. I would ask that a motion be made to accept the electoral board's exhibits into evidence, and those would be exhibits 1 through 7.
So moved.
Second.
On the motion to accept the exhibits 1 through 7, did this include the rules of procedure as well? Or is that a separate one?
It does. The rules of procedure are Exhibit 6.
I thought I heard that. Okay.
Yep.
Okay, Chairman Rogers. Chairman Rogers, roll call.
Sorry
Okay,
about that. Head on mill. Aye.
aye. Clerk Dugan, aye. Trustee Henyard.
Aye.
Motion carried, 3 ayes.
At this time, I would ask that the objector's attorney provide a summary of issues raised and state whether they are purely legal or if there are factual matters to be determined.
Thank you. And thank you, members of the board, for your time. So this case involves Gail Towers. Gail Towers, on her nomination papers, purported to live at an address in the village of Dolton. However, upon information and belief and based upon reasonable investigation, Gail Towers does not in fact live at 14517 Van Buren in Dolton. She does in fact reside at and has maintained residency at 15241 Naughton Drive. We intend to submit evidence to show that Miss Towers actually has a deed with her name on it for the property in South Holland on 15241 Naughton Drive. That she and her husband, Houston Towers, in fact, purchased the property in, I believe, December of 2016. They also have been collecting a homeowner's exemption on that property. And to collect a homeowner's exemption, you actually have to reside in the property. So they've been collecting a homeowner's exemption on the South Holland property. And in addition to that, the property at the 14517 Van Buren is actually not owned by either Houston Towers or Gail Towers and is instead owned by Jerice Towers, who's also collecting a homeowner's exemption. So the property that they purport to live at contains a homeowner's exemption of somebody else, Jerice Towers, possibly a relative, I'm not sure. And the home at which they have been collecting the homeowner's exemption, which is the home that I submit that they actually have residence in, not the home in Dolton, that at that home, again, they've been collecting a homeowner's exemption since at least 2016. So based upon the reasonable investigation already performed and the additional evidence that we hope to get through the subpoenas that have been requested, it's our opinion and it's our submission that Gail Towers is in fact not a resident of the village of Dolton, has not been a resident of the village of Dolton for 1 year as required under law. And that's further bolstered by the fact that she just had some inspections done at the property in South Holland. And on those inspection reports, the village of South Holland has deemed her and her husband Houston to be the owners of the property. If they're owning property, if they're collecting a homeowner's exemption on the property, they are residing in the property and they do not have residency elsewhere. And as such, the objector's petition should be sustained, and that will be what we will be presenting and requesting through the subpoena requests that have already been submitted. Thank you.
Okay. Mr.
Now-
Giannola?
Yes. Members of the board, where it's so easy to be a said. There's been much said about the ownership of property. This is not the issue raised in the objector's petition. The ownership of property, quite frankly, has no bearing to the provisions of the Illinois Election Code. The issue is one of residency. There's allegations of residency. However, the supporting allegations put forward by the objector, or I should say the unsupporting allegations put by the objector, point to the fact that there's real property owned by the candidate. The fact that the candidate owns real property is not dispositive of the issue of residency. Likewise, the allegation is to the claim for a homeowner's exemption or a homestead exemption for purposes of tax assessment purposes isn't relevant to the determination of whether or not the candidate is a resident at the address stated on her statement of candidacy. Many people own more than one property. I myself, if I were a candidate, if I were a resident of the village of Dolton and I lived in the village of Dolton, someone could come along and claim that I don't have residency in the village of Dolton because my name is on a deed at 18511 Torrance Avenue. Well, that has nothing to do with residency. That's an address of my business for which I own property, but it has no bearing on the issue of residency. many people fortunate enough to own several properties within a village might have 1, 2, 3 properties in the village. That doesn't address the issue of residency. And the fact that the homestead exemption might or might not have been claimed is a red herring, because homestead exemptions aren't limited to just the owner of the property. An individual with a leasehold interest can be eligible for the homestead exemption where they have an obligation to pay the real estate taxes, and that's their place of residency. So much has been said about multiple properties, but little has been said of the elements of residency, which is set forth in a recent Illinois Supreme Court decision out of the city of Chicago, the Maxim decision, which gives quite good information as far as what needs to be said or needs to be determined when someone objects or attacks residency of an individual. I believe all the facts will be borne out to show that the candidate is qualified, filed a statement of candidacy, and is rightfully seeking her placement on the ballot in the February primary in the village of Dolton.
Just very quickly in reply to that, it is our contention that the homeowner's exemption is actually very important. Even when somebody has a leasehold, their name is then on it. It is on there. Right now, we have a situation where Ms. Towers and her husband are collecting a homeowner's exemption in South Holland, but allegedly they're not living in South Holland. Allegedly, she is living in Dolton, at this address in Dolton. So it's one of two things. Either she's fraudulently collecting a homeowner's exemption or she doesn't live in Dolton. So.
Or it's possible that the homestead exemption might have been claimed by an estranged spouse and not claimed by the candidate. That's what the facts will have to bear out.
Okay. The next thing on the agenda is regarding the motion for subpoena. I would ask, are the parties ready to for a hearing on the motions for subpoenas, or would you rather set that for whenever we come back on the motions to strike and dismiss, which I assume are going to be filed?
Well, I think we kind of, if I may, I think we kind of have a short time frame. And obviously these subpoenas, it's going to take some time to get them out and get the information back. Well, we do have at least, 6 or 7 documents. But we do have at least 6 or 7 documents that will potentially be helpful to us and to prove the allegations that we made in good faith. I think it'd probably be better if Mr. Giannopoulos is prepared. I'm prepared to argue the motion as it relates to the request for subpoenas and get the board's ruling to see if we can even get the subpoenas. If we can't get the subpoenas, then we're just going to have to go forward with the motion to dismiss. And I'll obviously have to make my record as it relates to the board's either acceptance or denial of the subpoenas, or granting or denial of the subpoenas.
I'm prepared to proceed as well.
Okay.
Attorney Jaworski, in our earlier case in regards to Higgins, and you mentioned the fact that you're willing to forego the subpoenas. I thought you meant in both cases, but you're just
No, sir. No, there is 2 different issues. Higgins is simply limited to the middle initial.
right.
Here we have a much more fact-intensive issue as it relates to the status of the candidate and where she lives.
Now, who are you?
And I would also like to amend my request for subpoenas based upon information that the candidate just stated. I would also like to add a subpoena for the personal testimony of Houston Towers.
Okay, so you're looking to go forward with the subpoenas?
Yes, sir.
Okay. And of course, that's, as you mentioned earlier, that's a very time-consuming manner. So are we going to just argue for the subpoenas today? And if the board decides to go forward with the subpoenas, then you'll ask for a date until the subpoenas are actually issued?
Yes, I mean, if the board agrees to allow me to issue the subpoenas, we'll be sending, I'll just need them back signed. The dates will need to be changed on them, obviously,
Right.
but I'll just need them back signed, and then we will issue them.
Okay.
and send them out.
Now, you know, the matter of issuing subpoenas and catching up with the person to be served could be a very timely matter.
That's precisely why I wanted to start this process. And
Right.
that was why I submitted the request for subpoenas the day after our initial hearing.
Yes. Okay. So why don't we argue the subpoena matter? Let the board vote on it today, and then we'll see where we go.
And well, as it relates to the subpoenas that we requested in this case, I think that the subpoenas that we requested in this case are squarely on point with the information that is being sought as it relates to the candidate's residency in the village of Dolton or in the village of South Holland, which we contend that she is actually a resident of the village of South Holland. Her tax returns, I believe, would be very illuminating to see where exactly she files her taxes and which property she is claiming as her house and her taxes. The Cook County Treasurer's Office obviously would have information as to the taxes paid on the properties, who owns the properties. The Cook County Clerk Recording Department is also going to have such relevant information, as would the assessor and the Board of Review. The Elections Department would give information as to where Ms. Towers has cast her ballot in the last few elections, as well as where her current voter registration is. The Vital Records Department would potentially give us information related to Mr. Towers and Mrs. Towers' marriage license and marriage status. The Commonwealth Edison bills, the NICOR bills, and People's Gas bills, those would all give potential evidence as to whether there is actual occupancy at these addresses. The Village of Dolton subpoena would enable us to have the information required, or I'm sorry, the information that would be relevant to determining whether the candidate in fact is occupying the property in Dolton and whether she has ever occupied the property in Dolton to establish her residency. And finally, the Village of South Holland, we already have some very, very great information from the Village of South Holland. And I thank them for a timely response to a FOIA request. And the Village of South Holland, you know, clearly that is something that is extremely relevant because the candidate allegedly lives in South Holland. There's water bills showing water usage in South Holland, as was submitted with our response to the objection to our motion or our request for subpoenas. And in fact, there's even an inspection report on December 4th, 2020 at 10:30 a.m. By Inspector Mike Hampton of the Village of South Holland, where the owner of the property is listed as Houston and Gale Towers. So it specifically states both. So based upon, and also the property owner with the application that was submitted for a permit, it looks to me like this is Gale Towers, possibly Gale Towers' signature. I'm not quite sure, but Gale Towers seemingly submitted a building permit application, or through her contractor submitted a building permit application for a re-roofing of the property in South Holland. That was submitted on November 25th, 2020. So they're collecting a homeowner's exemption. They're fixing the place up, putting a new roof on. She's listed as the owner. She's listed as the owner on the deed from 2016. She's listed as the owner on the property results. On the FOIA and the property inspection report and the request for a permit as recent as November 25th and December 4th of this year, not last year, this year. So those things show that there is a reasonable basis for these subpoenas. And these subpoenas are designed specifically to elicit additional and admissible evidence as it relates to the candidate's lack of residency in the Village of Dolton, abandonment of said residency, if it ever even existed, and actual residency in the Village of South Holland. Thank you.
Okay, as the Attorney General Office had mentioned earlier, that it's not illegal, and I'm not sure if you use that term, to own and or possess a additional properties. And those additional properties should be in that person's name. Now, you mentioned the fact that NICOR and ComEd has indicated the residency for her there. Now, I'm not sure of any ComEd representative and either NICOR representative that will actually say, yes, I saw her in the residence there and that she's living there. They just merely identify the person that's responsible for the electric there or the gas that's there. And that again can be in a landlord's name or a person that has additional property. But I'm not sure, Attorney Giannopoulos, if you want to comment on this and before we take a motion to move forward on the subpoena or not.
Yes, if I could have the opportunity to respond. First of all, on a preliminary basis, this board has adopted rules of procedure. It was done today, although they were provided at the last hearing. And I direct this board's attention to their Rule 3M, subparagraph M as in Mary. And that rule provides that the electoral board may, on its own motion or upon motion of a party, and I am moving and I have invoked Rule 3M in my objection to the request for the issuance of the subpoenas. So again, the board may, on its own motion or on motion of any party, require the objector to make a preliminary showing that certain of the factual allegations in the objector's petitions are pled in good faith based on knowledge, information, and or belief formed after a reasonable inquiry. So that's what I would like the board to focus upon, is the requirement that the investigation has been conducted and pled in good faith based on knowledge, information, and or belief formed after a reasonable inquiry. The reason I believe that language is important requires the board, before granting any subpoenas, to make a consideration as to the due diligence performed behind the investigation into the objector's petition. The objector's petition, the board will note, is not verified, and it's not required. I'm not suggesting that a verified pleading is required by the election code when it comes to an answer. You do start out, however, with nomination papers that are presumptively valid, provided that that there is no valid objection pending, that the nomination papers, which are sworn to under oath, notarized by a notary public, so you have verified opening documents in the nature of nomination papers, and then you have an unverified subjecting someone to penalties of perjury, an unverified objector's petition. And again, typically where one would find in a document containing a verification, there would be the language attesting to the fact that a reasonable inquiry was conducted prior to the issuance of the document at issue. In the objector's request for the issuance of subpoena ducis tecum, she says the following with respect to the individual entities who are subject to the request for subpoenas. She asks for all entities, agencies, companies, or persons maintain or likely maintain relevant information related to the candidate's residency. These people likely, not they do contain, but they likely contain is the allegation. So in other words, maybe they do, maybe they don't. I'm not sure. I don't know. But give me a subpoena and I'll use that awesome power to delve into people's private affairs. Again, the very first thing asked for in this instance are tax returns. Tax returns somehow have a bearing on the issue of residency? I think not. Rule 3, the board rules do not allow for the issuance of subpoenas where the person has been subpoenaed and the materials being subpoenaed are likely to maintain relevant information. Rather, the board's rules require a showing that a person or materials are relevant Here, no such showing is made. And I refer the board to Rule 3D, where it says, and a statement describing what is required is a statement describing that the subpoenaed persons and/or materials are relevant to the proceedings. Not likely, as alleged in the subpoena request, but they are relevant. In other words, requiring that there be some due diligence performed after a reasonable inquiry and some affirmation as to the issue of residency, which none is made. The proposed subpoenas are no more than a fishing expedition unsupported by facts and not based on a reasonable inquiry. Allowing subpoenas to be issued under the circumstances would allow an objector, such as is attempted to be done here, to file an unverified objector's petition without conducting due inquiry and use the powers of the board through the election process to go on a fishing expedition. This is recognized by Illinois courts as being unacceptable, and as People v. Cannon is cited in the brief, quoting to United States versus Nixon. Again, the use of the subpoena powers isn't to try and secure information. If it exists, maybe it'll be there, maybe it'll help me. It's to secure relevant information by this board's own rules that is in the hands or the possession of a third party. So in other words, it's not a shoot first and ask questions later standard. It's use the subpoena powers to secure the attendance of witnesses in 4 circumstances. It requires a showing that materials sought are evidentiary and relevant. The material is not otherwise reasonably procurable by the exercise of due diligence in advance of trial or hearing. That the requesting party cannot properly prepare for trial without such production, and the failure to maintain materials might lead to unreasonable delay of the hearing or trial. And number 4, the application is made in good faith and not intended as a general fishing expedition. You heard from counsel, she stated that these subpoena parties to which the subpoena is requested, they may contain information as to relevant residency. Not that they do. It's not enough to allege that there might be relevant information. The standard is that there's an assertion that there is relevant information. It's not otherwise available, and I need the power of this board to bring the documents into the hearing process. So for those reasons, I believe that the motion for the issuance of subpoenas should be denied, given that the objector has failed to set forth a sufficient basis required by this board's very Rule 3D and is showing that the materials are relevant to the proceedings. That assertion was not made. The request for subpoena should be denied.
If I may, in reply, the board rules were certainly adopted after the drafting of the objector's petition. Nonetheless, as shown clearly in the response to the candidate's, the response to the candidate's objection to the objector's petition, or to the subpoenas requested by the candidate, there was an investigation done. There was due diligence done. The objection wasn't filed until, I believe, if my dates are correct, let me just double check. Okay, the objection, I believe, was filed either December 1st or December 2nd. I want to say December 2nd. And on November 26, 2020, a screenshot was taken of the Recorder of Deeds online search to show that, in fact, Gale and Houston Towers purchased the property at 15241 Naughton. Then, again, on November 29, 2020, the property tax portal for Cook County was reviewed. And it was determined that Houston Towers, who was the owner of the property, who was also married to Gale Towers, was accepting a homeowner's exemption at 15241 Naughton Drive. In addition, there was a FOIA response that was for a FOIA that was submitted on November 30th, 2020. that was not received until December 14th. However, that FOIA clearly states that there was an inspection that was done on December 4th, 2020, as well as a request for a permit for the property on Naughton in South Holland. All of this and the other exhibits attached to our response to candidates' motion to deny the subpoenas or objection to the subpoenas, all of that shows that reasonable inquiry was performed. Due diligence, in fact, was performed. I submit that this is actually more due diligence than most objectors do when they file. In addition to that, while the statements in the objector's request for subpoenas, as well as subpoenas themselves, may say may or likely, the reason is because, number one, there may be more than one Gale Towers. We're trying to give them as much information as possible to hone in on the individual that we believe has not established residency in the village of Dolton, and instead is a resident of the village of South Holland. We don't know what the water usage bills are going to show because those documents are not always subject to FOIA. We did FOIA some of those and we received some back for the village of South Holland to show that there is water usage going on at the village of South Holland. We cannot know what a NICOR bill or a People's Gas bill or a ComEd bill is going to show without FOIAing those. Those are not public, I'm sorry, without subpoenaing those. Those are not public agencies. No matter how many FOIAs we file with them, they do not have to respond to our FOIAs. So the only manner in which we can find the discoverable information, which we believe would lead to admissible information to show that the candidate, in fact, based upon the reasonable inquiry and due diligence that has already been performed, that the candidate, in fact, does not reside in Dolton. She actually is a resident of the village of South Holland at the property on Naughton. And in addition to that, the statements regarding the ability to own property and own multiple pieces of property, yes, that's true. Somebody can own 30 pieces of property. I mean, we obviously have big time real estate investors that own multiple pieces of property. However, you can only collect a homestead exemption for one parcel of property. Mr. Houston Towers and Ms. Gale Towers are currently collecting a homeowner's exemption for the property on Naughton in the village of South Holland. As recent as December 4th, 2020, an inspection was done. And on that document from the village of South Holland, it stated that the property owners were Gale and Houston Towers. The request for a permit was filed on November 26, 2020. And again, that request for a permit detailed Gale Towers as the owner. If they're separated, that happened really quickly because they were obviously just a couple weeks ago trying to get this roof done at the property in South Holland, the property at which they likely reside at because that's where they collect the homeowner's exemption. As such, these subpoenas are completely relevant. They are in line with the provisions required under Section 3D. They were filed in compliance with Section 3D of the board's just recently adopted rules. And they also comply, and I believe that based on candidates 3M motion, which is the request for us to give a preliminary showing, that preliminary showing has been made. There are 6 documents attached to the response that clearly show that there was a preliminary investigation and due diligence done. And as such, we ask that the subpoenas issue.
If I could briefly state, council has indicated that the records, the subpoenas are appropriate, and the invocation of the civil standard of the circuit court is used, and that it's asserted that it would likely lead to relevant information or likely lead to admissible information. That's not the standard imposed by Rule 3D. Again, I'm going to quote. And a statement at the time of the request for the issuance of subpoenas, it states that the party requesting is to include a, and quote, statement describing why the subpoenaed person and or materials are relevant to the proceedings, not likely to lead to relevant information as is done in discovery and civil proceedings. We're not governed by the Code of Civil Procedure. We're governed by this board's rules. And this board's rules doesn't allow for the use of subpoenas for the possibility that they might result in the disclosure of admissible information, it's a very limited nature of subpoena that can be sought, and that is where the party is aware after reasonable inquiry, knowing that the information is in the hands of a third party, but they need the assistance of this board's power to capture the document and make the document be compelled for production, or make the person be compelled for production. We're not held to the standard of likely to lead to relevant information. It has to be relevant and known to be relevant in the first instance.
If I may, just briefly in response to that, that specific issue, the request for a subpoena states, our request for a subpoena states that all entities, agencies, companies, and persons maintain or likely maintain relevant information related to the candidate's residency. The qualifier of maintain or likely maintain is simply a qualifier. We first started off with maintain. They maintain this information. If electric is at the property, then there should be an electric bill from ComEd. If there's gas at the property, there should be a gas bill from People's Gas or Nicor. If water is running through the property, there should be a water bill. All these things are things that are common as it relates to property ownership. So to state that they are maintained or likely maintained, it's to just focus on the likely is totally ignoring the rest of the words in the motion.
I'm sorry, go ahead.
No, as the movement, I won't belabor the points. I've said what I believe I needed to say.
Okay. Attorney Jaworski, you mentioned the fact that you had substantial evidence from the village of South Holland in regards to residency of the candidate here. If that information that you've gathered is so overwhelming, I would say from your testimony that you would think that it's sustaining or substantial. Why do we need or why do you think any further information from the subpoena process would be beneficial?
Okay, so first I just want to correct the record. I'm not testifying, I'm arguing. So just want to make sure that the record's clear. I am not under oath. I'm just simply arguing. That said, I still do think that it's substantial information, and typically through a subpoena, it's not just the gathering of information, it's the gathering of information that's been gathered pursuant to subpoena so as to make it admissible. If candidate's attorney is willing to stipulate to the admissibility of the documents that I received via FOIA from South Holland, that would certainly make things a lot easier. But I don't know that a candidate's attorney is willing to stipulate to that. And, you know, and I can understand if he wouldn't be. So that said, because of that, that's why we need a subpoena. And there may be additional documentation that with a subpoena, you get everything. You don't have the redactions. With a FOIA, you have the redactions. So you can have a water bill with a FOIA and potentially have the name or the address redacted. So there's limited information that we can get on a FOIA. We could basically, you know, we could get on into the car in a FOIA, but we can't start the car because we don't have the key.
And you think you'll be able to start the car with the subpoena?
I think the subpoena will give us unredacted information and, you know, potentially fill in holes that may be missing because we are not privy to that information as it relates to the Freedom of Information Act.
You know, when you talk about, now you're talking about the appearance of that candidate's name on a deed and or an inspection report, but with the signature alone and with the filing of a deed or a deed in the name of the recipient, if you will, in this case, you're saying the candidate, that doesn't prove occupancy. And And it seems like what you're arguing here now is occupancy for,
I'm
for the-
arguing residency.
okay. And residency residency also has to mean occupancy, if you will.
So residency is a tricky little beast.
Exactly.
And I think us election practitioners recognize that.
Sure.
The Maxim case, did provide a little bit more information on residency, but it's basically physical presence and an intent to remain. And then there's a question of whether residency has been abandoned. In this situation, we don't believe that there's even physical presence or an intent to remain. Since 2016, the candidate has owned this property in South Holland. From 2016 on forward, the candidate and her husband have collected a homeowner's exemption. And as recent as November 2020 and December 2020, there were inspections and a new roof put on the property in South Holland. So that, those same facts don't exist for the property in Dolton. And everything that we presented show that this property in South Holland is owned by Gale and Houston Towers. A homeowner's exemption has been collected and work is being done on the property as if somebody is residing there. There's water bills that show that somebody's residing there consuming water. So, the more information that we could certainly get from the Village of South Holland, as well as any of the other additional persons that we had listed in our request for subpoena. Now, I guess the more information the board will have before it to make a decision as to whether Gale Towers, who both of you are, two of the board members are extremely familiar with, whether Gale Towers in fact lives in South Holland or if she lives in Dolton, and whether she has residency in South Holland or whether she has residency in Dolton.
Hypothetically, if the board, you unsuccessful today in front of the board in regards to getting a subpoena, what's your next move?
I'm sorry, there was a little bit of a breaking up there. Could you state that again?
Hypothetically, if you're unsuccessful, if you are unsuccessful, or if this board is unsuccessful granting you the subpoena power, what's your next move at that point?
Well, I assume, obviously I would make my record that I think that the board's decision is correct, is incorrect. I would reserve that issue on appeal. And, maybe I would consider the possibility of going up on an interlocutory basis to force those subpoenas to be issued. I may have to go to circuit court to get my subpoena request heard and see if the circuit court would force the electoral board to issue said subpoenas. If that was unsuccessful, then we would have to, obviously, I would be contending, I assume, with candidates' forthcoming motion to strike and dismiss the objector's petition. So we would be traveling on a parallel path of that. And I would potentially be stuck at this time, depending on what the circuit court says, with the evidence that I have already submitted, which I do believe is substantial. I believe the evidence submitted shows to any normal unbiased person that the candidate in fact lives in South Holland and resides in South Holland and does not maintain a residency in the Village of Dolton. In fact, it's actually her sister or somebody else who's got a homeowner's exemption. Maybe they own the property in Dolton, and maybe they've rented it out to Houston's sister, Jerice Towers. I'm not sure. But until that is all borne out, the facts that you have in front of you are that the property in Dolton is not owned by Gale Towers. The property in South Holland is owned by Gale Towers. Both properties have homeowners exemptions being collected on them. The property in South Holland has had work done on it as recently as 3 weeks ago, where the person signing off for the work or requesting the work is Gale Towers, and listed herself as her and her husband as the owner of the property. So I think the evidence that we have already is pretty substantial. And I think, denying a request for a subpoena is essentially denying my client the due process that they should be afforded.
Can I ask why on the majority of the subpoenas, you're seeking information for 2018 and 2019 as well as 2020, when the residency requirement is a year before the election? So I guess the question is, how is 2018 and 2019 going to lead you to relevant information? Why 2018 and 2019?
Just wanted to see if there's any historical information in some of those documents that would shed some light on whether the candidate in fact was a resident. So for instance, if the candidate, put the property in a trust and we weren't aware of that because that was in a 2018 document and we only asked for it from 2019 or 2020 forward, then that would be to, yield relevant information. I would have no problem with limiting the scope of the subpoena to 1 year, to the, I guess, year 2020 and 2019. I mean, I prefer 2019 and 2020, but if candidates council will agree that the subpoenas could issue and we could limit the scope as it relates to the year, I would be agreeable to that.
That does address one of my concerns in terms of the scope of the subpoena, but I keep coming back to the fact that this board's rules require that the materials are relevant to the proceedings, and the preceding answer, when asked why the time duration, the response was, well, we just wanted to see. That's the very thing in United States versus Nixon. That's the issue. It's a fishing expedition. I mean, I can't make it any clearer than that. I don't know what records are there, but they might be there. That's the difference in the civil proceeding, which allows for the discovery of information likely to lead to the discovery of admissible information. That's the standard in the civil courts, not the standard before the board based on the rules that have been adopted. I'm simply seeking compliance with the board's rules.
And if I may, in response to that, the request as it relates going back to 2018 and 2019 is again to understand the background. It's not to say, well, we may find something. I mean, even if we found something that had a 2018 date that said that she lived someplace else, that doesn't per se help our case, but it gives us the background so that we can understand the full context of where the candidate actually resides. But again, I am fine with limiting the scope of the subpoena to January 1st, 2020 through the present, if that will please the board. But I do think that we have shown a substantial showing of potential of relevant information to show that these subpoenas are based in law and compliant with Section 3D.
On behalf of the candidate, without waiving compliance with the rules, to the extent that the board were so inclined, and again, I'm going to stand on the rules, but to the extent the board would be so inclined to issue, to compel the issuance of subpoenas, which again, I'm not waiving my objection. I stand on the fact that this is beyond the scope of the board's rules. For example, tax returns, even for a given year, the relevance of tax returns to this objection, other than an address that might be on a form, and an address is far from a residence, that's an example of what I believe to be the fishing expedition.
I'd be happy to actually I just want the address. You could redact everything else in there and do the front page. I just want the address.
I'm not sure what the significance of the address would be.
Well, where somebody is filing their taxes is usually where they live. I mean, I don't file my taxes from my office. I file my taxes from my home. I list my home on my taxes. I list my, where I'm collecting a homeowner's exemption on my taxes.
You know that on a tax return, a post office box is acceptable also.
Sure. I would want any information on the tax return that actually has anything related to the properties.
Mhm.
So, I mean, everything else could be redacted. I don't care about the candidate's financials. In fact, I don't even want to know that. I certainly don't want her social security number.
Right.
I just want to know what properties she is claiming a homeowner's exemption for.
That's available on the assessor's website. If
And the
she's the one,
address.
if she's the one claiming that assertion has been made, she claims that hasn't been established that she has claimed a homestead exemption.
I've
Jointly
said
held
they.
property.
I've said they.
There's-
As joint owners of the property, because they
Yeah.
still are, they are
it's a
owners.
It's a significant point.
Sure, but they are joint owners of the property. He may be the one that has filed for the exemption, but under the documents as per the Cook County, well, no longer the Cook County Recorder of Deeds, now the County
Division.
Clerk Recording Department, according to the documents on there, they are still joint owners of that property.
Okay, if there's no further arguing on this, I would like for us to make a motion to vote on the matter.
Well, I got some questions. Is it for discussion for the board members yet, Mayor?
Go ahead.
Okay, well, first I was a little confused because I was trying to understand, was you the attorney, Mayor, or was it Dennis was the attorney for the other person? So you was doing more argument than he was. So
as a board chairperson, as a board member, I'm entitled to ask questions of the attorneys and or the presentation to the board, just like you want to make comment right now.
yeah, it's a comment, but not an argument, but yeah. So first I can understand when it was first opened up and you allowed for Tiffany Nelson to basically give her argument, you argued right after. So that's why I was pointing out that you guys will be biased because you didn't allow Dennis Giannopoulos to go next as you did previous with other attorneys. Normally it's the first attorney, then the second attorney, but you did the debating first. So that's one reason why I keep saying y'all gonna be biased in this. Secondly, Attorney Tiffany Nelson, I wanted you to know, I didn't understand what was the reason for the mayor asking you what would be your defense if you're not successful. I didn't understand why he needed to know your next move before he made his decision here. Just a rule of the wise, I would never give anybody my hand or show my hand before they tell me what they're gonna do. Then I show them what I would do. So I think that's how you should handle it, even though you gave us what you're gonna do, and that's fine. So I guess that's gonna help him with his decision because he would know your next move. So I do like the fact that everyone is talking and discussing what's going on. I do want to agree with the subpoenas and moving forward. I do think we need more clarity as to where she stays, because if I'm not mistaken, correct me if I'm wrong, either attorney can correct me. Is that an apartment building? Because I don't know. Is that an apartment building that she stays in for Dolton? And then is that a house that's over in South Holland? Because if it is, I don't understand who will be staying in an apartment and then doing a ton of work on a house in South Holland. So I'm confused with that. Is that an apartment or is it a house for Dolton address? Do any one of you guys know?
I believe it's an apartment.
Okay.
I'm not aware.
Okay, well, that's my concern because if you pull permits and you pull all the things that you're stating, I too don't agree that someone will put a homeowner's exemption on a property that they're not living in. And I do see that as fraud to the government as a whole if basically Gale Towers did do that. So I would like to see the records as it relates to her dress, and I agree that it don't have anything to do with, we want to know her financial information. I am looking for if she stays here in Dolton, because she do sit on the park board, and if that's the case, that wouldn't be good for her because she's defrauding the residents as a whole, and she should stay where she governs, which is Dolton. So if she do reside in South Holland, she should go run for office in South Holland and withdraw from the Dolton board here. So that's my concern as it relates to Gales Tower. Thank you.
Trustee Henry, apparently you are still confused because I was not arguing. I can make a comment. There's no procedural protocol, if you will, that the second attorney has to answer right behind the first attorney. He did in fact speak. I want to get clarification from the objector's attorney in regards to movement. And there's nothing wrong with that. And she clarified her procedure or her next
Well,
movement.
just to be clear, I just wanted to put on the record what all the various options are. I mean, there's other options, and I certainly didn't, give my full hand. But yeah, you asked a question, so I wanted to let you know what the potential avenues are that we could be exploring.
Exactly. And she said that she was first confused, and to clear up her confusion or try to clear up her confusion, there's no protocol in regards to when I'm going to ask you questions or when the next movement of the rebuttal from the other attorney. So.
Right. I guess, Mayor, because my concern is I see you had no questions as it related to Dennis. All your questions was geared towards Tiffany.
Doesn't
So
matter.
that shows
matter.
me, I'm just saying, I'm just pointing out the facts.
It
So
doesn't
that's what I'm sitting back observing. So I didn't see you ask him anything as it related to the candidate if we're not going to be biased, which I
doesn't
know
matter.
that's your candidate that you're running. So that's why I'm saying then ask both attorneys whatever their arguments is, but you did no such thing. So I am concerned about that. And then as it related to P.O. Box, I was researching on my phone here. P.O. Box is acceptable only if the post office does not deliver mail to your home, because you guys were suggesting that it may be a P.O. Box on her tax returns. So that's the only way it's acceptable. But I do doubt that she used the P.O. Box. I hope she used one of her many addresses on her tax returns. So that's why I do agree with the subpoenas. Subpoenas is basically to prove that you're innocent. So you gather the facts. I don't believe it's sufficient expert. I just think that we are trying to get the information so we can move forward.
I'd just like to, if I could make one comment.
Sure.
The reference to proving that you're innocent, I have to take issue with that. Subpoenas aren't used and doesn't place a burden on an individual to prove that they're somehow innocent of an allegation. I just wanted to make that point.
Okay, well, point made or heard. Basically, I just think it clears a person. We was here, once again, I stated before in 2017 as it related to Andrew Holmes staying here in town, and he had to provide us with almost similar documentation as she's asking for to prove if he stayed here in the village of Dolton. So I didn't understand what was the issue now with getting the same stuff when she is an elected official, meaning Gail Towers. So she should have all that at her fingertips, honestly.
Why don't we let this record show reflect that the decision and or the electoral board electoral board appearing and making a decision 2017 has no bearing on today's actions. Now, if there's no further comment from anybody, village attorney, did you want to comment on anything? Well, if there's no further comment, why don't we
I actually, to my comments previously, well, a couple of things. One, there are a number of subpoenas that are being requested. And I don't think that the board needs to motion on the request in its entirety, that the board can sort of pick and choose which subpoenas are issued and which ones aren't. And the other thing I would like to say is that the subpoenas do ask for 2018 to 2020. The residency requirement is that you have to be a resident for 1 year prior to the election. So I don't know that some of the information that is being requested really meets what the requirements are for the issuance of a subpoena. I would take note of Mr. Giannopoulos' argument regarding the electoral board powers and the rules, that Rule 3D does state that issuing subpoenas requiring attendance of witnesses and subpoenas juicis tecum. However, the request for the issuance of such subpoenas shall be made to the electoral board and its attorney in writing, and shall identify the person or entity being subpoenaed and any materials requested pursuant to the subpoena, the purpose of the subpoena, and a statement describing why the subpoenaed person and or materials are relevant to the proceedings. So that's the threshold that Mr. Rowski, I'm sorry, I botched your last name. Under our rules, that's the threshold that she has to make. You have a copy of the motion, you have a copy of the rule, or her request, you have a copy of the rules, you have a copy of each of the subpoenas and information that's being requested. And you have a copy of the candidate's objection and the objector's response to that objection. So the question before the board is, I guess, did the objector meet this threshold? And she, did she meet the threshold for all of the subpoenas, only some of them? And then if so, the subpoena should be issued. If not, if there isn't a statement describing why the subpoenaed person or materials are relevant to the proceedings, and then they shouldn't. And I'd also like to note, and I guess I have a question, because there was a request at the beginning of this hearing to actually add a subpoena that wasn't even included in the motion. So I guess on that subpoena, because the rules do state that the request has to be made in writing.
Yes, and I would,
in and of itself doesn't follow the rules.
so if I may request, so basically I made that request based upon the candidate's attorney's assertion that the candidate and her husband may in fact be separated.
Okay.
So that was based upon that. So the board rules do not provide a time frame in which I need to make my request for subpoenas. So if need be, I will file a written request for subpoena and we can go through this whole process again. But for the sake of judicial economy and
Right.
expediency, I was making that oral request now based upon candidates' counsel's representations as to the status of Mrs. Towers' relationship with Houston Towers.
To be clear, I never made a representation. I threw out the possibility as an example. I'm not familiar at this point, so I'm not able to indicate the marital status. I use that, I believe, in the nature of an example of how you could have parties living at separate addresses, not being jointly living together, claiming the homestead exemption. So I just want that point to be clear.
Okay, so then just to clarify on my end, I will be happy to file a written request for a subpoena if that is what the board wishes. And we can obviously go through this exercise again as it relates to the subpoena for Mr. Towers. Or the board can hear my oral request, and so it's up to the board. I mean, I made the motion based upon what I had heard. So.
Okay, and that's why I do suggest as the board votes on the motion that it votes, I think, subpoena by subpoena. I know that is time consuming. However, because we have an oral request for a subpoena, and then you have a number of subpoenas, some are requesting documents going all the way back to 2018. Some are requesting documents. You have a request for the Department of Vital Records asking for marriage licenses. And then you have requests seeking documents for South Holland or the Village of Dolton, and et cetera. But that those are, in my mind, the questions that the board needs to be asking themselves as it relates to these subpoenas, and that is whether or not the objector has met this threshold for these requests. And then I guess the other question is, the scope of the subpoena, as we discussed previously, related to asking for information going beyond what going all the way back to 2018.
And just to clarify, as stated, I mean, I can make, if the board is agreeable to it, I will be happy to amend my subpoena request to be from January 1st, 2020 forward. That gives us the 1 year and a couple months, or even if I have to go April 1st, 2020 forward, I'd be happy to make that amendment.
So does the board have the list of the, and that's, I guess, the other question. The list of the requests for the subpoenas is in the objector's motion. If you want to reference what all is being requested.
I have a concern regarding the distinction that was made earlier between ownership and residency. And I understand why this subpoenas requested are relevant to ownership, or it may be relevant, let me say that. But I don't see how they are going to establish who resides at the property. Water usage, med bills. Okay, there are utility usages at the property. That doesn't tell us who. And from what I've heard, I think that applies to all the subpoenas that are requested. And in any event, so I'm inclined to deny the motion.
Mr. Arski, would you like to respond?
Yes, I would. Actually, I wasn't sure if the board was going to allow a response at this time.
Would the board allow a response?
Sure.
Sorry.
Okay, thank you. Well, the documents are sought to determine residency. I've already conceded that I understand that ownership and residency are two different things.
Mhm.
And yes, it may not show exactly who is living there, but it may. Here's the thing, when people open a ComEd account, they put their name on it. So if Gale Towers has a ComEd account sitting at the address on Naughton and does not have one at the address in Dolton, the presumption is pretty strong that she's actually living on Naughton in South Holland rather than in the village of Dolton. Same thing with the gas bill, same thing with the water bill. So all these utilities, we can't even tell right now whose name they're in because that information is not subject to the Freedom of Information Act. We may be able to tell as it relates to the water, but sometimes that information then gets redacted when people respond to FOIAs. So because of that, we can't tell right now as it is who holds those utility bills, who is the named person on those utility bills. So that's the first thing. Second thing is, sure, ownership and residency are two different things, but I think we have established some pretty strong evidence that shows that there is a homeowner's exemption being accepted at the Naughton address. Gale and Houston Towers are both on the deed of that property. Gale, in fact, is filing for permit applications to get work done on that property that they're collecting a homeowner's exemption for. There is no homeowner's exemption being collected by either Gale or Houston at the address in Dolton. So there's nothing to establish that she in fact is a resident of Dolton, aside from the self-serving affidavit in her statement of candidacy. There is nothing else. And so we have challenged that with evidence, some of which is clearly admissible evidence that shows that in fact, there is a question. There is a legitimate question. There's nothing about this that is a fishing expedition. This is a legitimate question about the candidate's residency. And as such, I think that every single one of these subpoenas is designed to elicit admissible evidence related to the candidate's residency. If there is nothing that comes out and we are incorrect, then of course we are incorrect. But somebody's got to have lights and electric and heat at these buildings in Naughton or at the one on Dolton or on Van Buren and Dolton. And without being able to subpoena that information, we can't determine who actually holds the bill, who is actually the named party on the bill.
But that again goes to the responsible party, which could be the owner, would be the owner, certainly.
It
Not
very well could be,
necessarily-
but it usually states the responsible party is being the owner or the occupant. I know that when I've owned property, you know, I owned a place that I rented out to some people. And when I rented it out, I had an owner's account that showed that I was the owner, but it also showed that it was being rented out to somebody. So there's ways that you can code these accounts, and that ComEd, NICOR, and People's Gas code these accounts to reflect that there is a tenant living in the facility, and the bill is under the tenant's name. In fact, some municipalities, the Village of Dolton and the Village of South Island, may even have ordinances stating that the water bill is the responsibility only of the owner of the property. Or they may have an ordinance saying that there's a joint responsibility as to the water bill. Or they may have an ordinance that states that it is the tenant of the property that is responsible for the water bill. So of course, that would be, you know, part of our investigation, determining who holds the responsibility for payment of the water bill, the occupant, the owner, or both. So that certainly is part of our investigation, but this is a preliminary stage. And I think that the board is trying to make a determination as to the validity of the residency objection at this moment, which I think is unfair, because we are here asking for subpoenas to determine and to further prove the allegations we have already submitted. To stop us at this point from getting the subpoenas that we believe that we are lawfully entitled to is stopping the investigation, is stopping the objection, is stopping everything before my client has been given her due process. That bolstered with the fact that we have 2 board members who we believe do have a bias, who have not recused themselves or disqualified themselves. You know, that all those things together do not look good.
No,
It's not relevant or irrelevant. It still comes down to in my view, the information you are requesting goes to ownership. It will not yield residency determination. There could very well be a scenario, and I don't know if this at all applies hypothetically, where you will find a candidate's not on anything at all as far as utility bills go. That does not mean the candidate is not living at that address. So I'm concerned about the relevancy of determining who's on a bill, period.
And just in response to that, I think that case is very different from the fact pattern that you just stated, where somebody has nothing, they don't have their name on anything. That's very different from somebody who has their name on legal documents in a neighboring municipality, showing that they are in fact owners and likely occupants of that property. I think that that's the distinguishing factor here, is that we do have evidence already showing this property in a neighboring community. I believe that where the property is located, you could probably throw a stone and throw it into Dolton, but it's not in Dolton. And that's the relevant inquiry.
And by being a single family resident, I do see a person putting their name on it. I don't see a landlord placing their name on any account that they're renting. So that's the reason why I'm saying yes for the subpoenas, that you will find out who stays where, because I have several rental properties and I never ever put my name on their bills. When I rent it out, it's the tenant's responsibility to pay their light, their gas, and then like you just stated, in some municipalities, their water bills. Here in the Village of Dolton, we do have an ordinance, which I did initiate when we first got in office, to have the water bill go in the tenant's name. So therefore, you have no issues, or if somebody get a shut-off notice, it go directly to the tenant. So I agree with you on getting the information, because I think that will help or show if the person resides there.
Attorney Jaworski, you mentioned judicial economy several times during our hearing here. And certainly if we were to move forward with the subpoena process, then that would not account for any judicial economy. I can
I don't agree with that statement. I think if the
Can I
subpoenas were
finish?
issued.
Can I finish? Can I finish?
Oh, I'm sorry. I thought you were turning it over to me. I
Never
apologize.
interrupted you. Never interrupted you. Because of that process, and I know the process, and I know the process of the subpoena. I know the process of the serving of the subpoena. I know the process of the acceptance of the subpoena. And in some cases, it's a lengthy process. In a lot of cases, most cases, it's a lengthy process. Now, when you refer to judicial economy, I'm not sure how that relates to the subpoena process if we were to vote for the subpoena process, because it's the process of getting the subpoena, ordering the subpoena, getting it processed, the process of the delivery and serving that subpoena, and which would in fact take us probably well past the holidays. And when you say you have right now, you have a substantial amount of evidence that you could move forward with, I'm not sure what benefit the subpoena would actually give to you. You're talking about tax returns, you're talking about occupancy, residency. That wouldn't in fact improve residency. I mean, even if in fact that candidate was served at that house, does not in fact mean that they reside there. It's the last known location that that person may have reside, may have occupied, and or may have been seen at even. So help me, if you will, how does this minimize the judicial economy?
Okay, thank you, Mayor. As it relates to judicial economy doesn't mean that, my client doesn't get their due process rights and get the ability to still prove and put forth admissible evidence in their case. When I was referring to judicial economy, I was talking about obviously consolidating these cases in any manner possible and consolidating the arguments between this case and similar cases so that we are not all sitting here going through the exact same arguments over and over again. These election cases are extremely fast-paced cases. They move at a lightning speed. Dennis, I think, will agree with me on this, that if we hear an election attorney or somebody coming in asking for a 30-day briefing schedule, we know that they've probably never done an election case in their life. So I understand that these cases move at a lightning fast speed, which is the reason why I submitted the request for the subpoenas the day after the initial hearing. There was an objection submitted, and this is obviously the first time, a little less than a week after the first hearing, that we are able to actually hear, that you guys are actually able to hear the arguments related to the request for subpoenas and the objection to same. So while I do, of course, always want judicial economy, I also need to be able to represent my client to the fullest and press forward and make sure that I am getting everything that I believe that my client is entitled to under the rules and under the law. And I think under the rules and under the law, my client is entitled to prove the objection that they've made. We've already presented 6 pieces of evidence that we believe help establish that the candidate, in fact, is not a resident of the village of Dolton and instead is a resident of the village of South Holland. These additional subpoenas and these requests for additional information are so that we can get information that does not need to be presented via a witness. It can be a document that is accepted into evidence because it was received pursuant to subpoena. We would also then get documents that are not redacted. We all know, that when somebody files a FOIA, there's a lot of stuff that tends to get redacted, sometimes rightfully and sometimes not rightfully. So this gives us access to the unredacted documents. And as stated previously, the utilities, those utilities, with the exception of the water, those utilities are not subject to the Freedom of Information Act. And while it might not give us all the information that we need, when you look at a case like residency, you don't look at one piece of the puzzle. You have to look at the puzzle as a whole. And you have to make a determination, you as the electoral board, looking at the puzzle as a whole. Does this person, in fact, live and reside legally where they say that they did on their nominating petitions? and I should have a right to prove my objection. I have made the minimal showing. I have made the substantial showing. 6 pieces of evidence already presented already show that the candidate, in fact, does own the property in South Holland. There is a homeowner's exemption on their property. Ms. Towers herself had requested permits for that property. Inspections were done. She's listed as the owner. All of these things lead to the inference that she likely is a resident there. She likely has residence there. And as such, our objection is in good faith. It's our submission that she in fact does have residence there. And it's not just likely that she does have residence there and not in the village of Dolton. We should be allowed to prove our case. Thank you.
If I may address the board. Perhaps for consideration, Rule 3F contains a provision where the board has authority to direct the parties to appear and confer for the settlement or simplification of issues and otherwise conducting a pre-hearing conference. Might it not be beneficial, given counsel's willingness to reduce the scope of the subpoenas from 3 years down to 1, which was one of my objections, although not asserted, and given the fact that there's been an indication of a concession on the federal tax issues, might it not be a good idea to give the parties an opportunity to see if they can reach some sort of a resolution with respect to the subpoenas, and report to the board's counsel with the results of those efforts? I may be able to, after giving an opportunity to review the subpoenas one at a time, notwithstanding the fact that I continue to rely on Rule 3D, but perhaps an agreement could be reached, particularly public information documents. I think that would be able to reach some sort of an agreement on the subpoenas. Just a thought, where we've been belaboring this for a while, so I'm just trying to push a potential resolution forward.
I'd be agreeable to that.
And when would you more than likely want to have this pre-conference before we take the vote on this?
Well, I've got a brief due in an hour and a half. I've got 5 briefs due in an hour and a half, so I'd really like to cut this off soon.
If I may, I think the thought would be that the parties deliberate. They send me an email with their agreement, if any is reached. I guess if one is reached, I guess the question would be whether or not the board would then, I think, still have to vote on that agreement, correct? So then we would just set this for a short date to reconvene on the subpoena issue.
That's fine. I know that tomorrow we're booked all day, right?
Yeah, so we would come back on Wednesday just for a vote either way, either a vote on the parties' agreement or a vote on the motion for subpoenas. It shouldn't take too long. And then that would be that. But it would give, it sounds like the parties have an idea of what subpoenas they might be able to say okay to. And if the parties say, okay, we're in agreement with the subpoenas, then I would assume that the board would also be in agreement. So I can't say for sure. So I think it does make some sense for the parties to have this discussion and maybe come back to us with a proposal on December 23rd. Would that, or well, send me a proposal by close of business tomorrow, and then we can have it up for a vote on December 23rd. Does the board agree with that timeline?
Is that in agreement with the attorney?
Yes, I'm fine with
Yes.
that.
Yeah, I'm in agreement.
Okay.
I missed it a little bit. I'm just trying to make sure I got it. So they just gonna turn something in to the board December 23rd. Is that what I heard? or no?
So I set close of business on December 22nd, so that way I have an opportunity to disseminate whatever their agreement is to the board for your review.
Okay,
And then assuming they come to an agreement, you guys would you would vote to approve the subpoenas they agree on December 23rd. If there is no agreement, then there would be the vote that I think everybody was intending on having today, which is a vote on the entirety of the objector's request for subpoenas.
okay, what time is this? So do we have to do another Zoom on the 23rd?
Yep, we're doing another Zoom on the 23rd.
What time is that? Because I have previous.
What time do we want to do a Zoom on the 23rd?
9 o'clock in the morning would be great. Because I don't know what everybody's schedule is, but my schedule kind of tight on that day. So I thought we weren't doing anything else this week.
I do apologize. I know everybody wants to get into the holiday spirit, but we have to take care of this first.
Okay, I'm fine with that, as long as it's in the morning. I can't do nothing after 11, so that's why I'm asking for.
When would people be available to Zoom on the 23rd?
I'm available anytime.
Don't we have a hearing on the 23rd?
We have a hearing on the 22nd.
Correct.
Not on
Nothing
the,
on the 23rd.
We've got nothing on the 23rd.
well, the morning wouldn't work for me.
Okay.
Okay.
Trustee Henry, you said, do you have any availability in the afternoon?
I do not. I have a whole event schedule. He knows that. That's why he's doing it. I got a whole food giveaway scheduled to feed 5,000 people. So I will not be
Okay.
available. So if you want to make it in the morning, I will make myself available, but I have to be on site. So
Can I make a suggestion
Yes.
to the board attorney? Maybe, and and Mr. Giannopoulos, I'm sure he'll obviously speak whether he's okay with it or not. I would be okay with Mr. Giannopoulos and I conferring, giving you by the close of business tomorrow what our opinion is, or what our stipulation is. And then you as the board attorney individually speaking with each board member and determining if anybody has an objection to that. If there is no objection, then the next time this board meets, they can just confirm that the subpoenas were issued as agreed to by the parties and put the stipulation on the record. If there is an objection by any one of the three, then obviously we'll have to find some time. And I hate to do this maybe on the 24th or over the weekend to hear this. And I don't think anybody wants to do that. So
I would rather have I think it would be better if the board were to vote on the record, so that way the subpoenas can get issued. And I hate to do this. Anybody want to have an electoral board hearing on Christmas Eve in the morning? Does that work?
that's
for
fine.
parties?
Wouldn't be my first one on Christmas Eve.
Then we can all wear our festive holiday gear.
Well, I would suggest, based upon the comments that was made by the clerk, based upon the comments that was made by myself, I think there's some indication in the direction of whether or not the subpoenas are going to be voted on to be issued. There's a conflict with Trustee Henry's date on the 23rd. I'm not available on the morning of the 23rd, nor am I available at all on Christmas Eve. So I would suggest that we put up for a vote right now.
That I think was our intention, Mayor, but if the attorneys believe that they can reach a compromise that is satisfactory to both sides, I'm not going to stand in the way of that.
Okay. Well, if that's the case, then we need to come up. Can we do it briefly on the 22nd, since we have a hearing on the 22nd?
Would the parties be able to confer before tomorrow?
I can confer anytime after 5 p.m. today. I just got to get all those other briefs on file.
I'm certainly, counsel and myself can get together as soon as she's done with her matters pending and address this in the early evening tonight over the phone.
Then do we want to set this for a vote on the subpoenas for tomorrow? I know our last hearing is at 2:30. I can put this on the calendar for 3, though I don't think we'll get to it at 3. We probably will get to it whenever our 2:30 ends.
Our first
Does that
hearing.
work?
Our first hearing is what?
Our first
12:30.
hearing is at
12:30.
12:30.
So do it.
Can we put it in for 11:30? And it's either yes or no, basically.
It's
Okay.
fine. I'm okay with that.
I'll have to, Miss Court Reporter? Is that okay? That's okay. All right, so we'll start tomorrow at 11:30. I'll ask Giovanni to amend the Zoom time for hearing on subpoenas. So then you would be able to get me some sort of stipulation so that means by
Hopefully, if I may, hopefully we could, if we can't get to the stipulation in writing, I think Mr. Giannopoulos and I can work out a stipulation to at least state on the record.
Okay,
Yes,
all right.
yes, I agree.
Does that work for the board members?
That work for you, Madam Clerk?
Yes.
Yes,
That works for you, Trustee Henyard?
Yes.
Okay. Now, I know that Attorney Tiffany, I know you have stuff to get to, but I assume that there are going to be motions to strike and or dismiss, correct?
Yes,
On this case, Attorney Giannopoulos,
yes, that's correct.
do we want to set the same schedule that was adopted in the Higgins case?
That would be fine.
Okay, so it's preliminary motions are due December 23rd at 5 p.m. Responses due Monday, December 28th at 10 a.m. Hearings / arguments on December 29th at 2 p.m. And we would need a motion to adopt that briefing schedule.
so moved.
Is that okay for everybody?
Yes,
Okay. It's been, I think Trustee Henyard motioned it. I'll second it.
No, Mayor, that was me.
That was you, I'm sorry. Okay, I'll second it. And let's take the roll call.
On the motion to approve the briefing schedule, Chairman Rogers.
Aye.
Clerk Dugan, aye. Trustee Henyard.
Aye.
And then just for, so that we have it on the record, can we have a motion to, I guess, table discussion on the motion for subpoenas until?
I'm sorry, can I interrupt? I'm really sorry.
Okay,
Is
sorry.
there any way that we can push this to noon tomorrow rather than 11:30?
Can you guys do noon
Sure.
tomorrow?
I'm available.
Yeah, we'll be at
I'm
it
sorry about that.
anyway.
We have something else earlier and we need to push it a half hour. Sorry.
Okay,
I think noon would work. I think the matter will be addressed immediately. So we won't interfere with our 12:30. Council, both councils, what do you think?
I believe so. I believe that let's hope we'll work in good faith and get it resolved.
Yes, okay.
all right, then, could I get a motion then to table discussions on the motion for subpoena until noon on December 22nd?
So moved.
Second.
Roll call.
Chairman Rogers.
Aye.
Clerk Dugan, aye. Trustee Henyard.
Aye.
And then finally, are there any other issues, concerns that we need to discuss today? Any other matters?
None that I can think of.
Then to close out the meeting, we just need a motion for recess of the board until tomorrow, December 22nd at noon.
Like you make
So
a motion to recess the hearing until tomorrow at 12 o'clock. No.
Second.
Chairman Rogers.
Aye.
Clerk Dugan, aye. Trustee Henyard.
Aye.
Motion carried, 3 ayes. See you everybody tomorrow.
See you
all
guys
right, thank you,
tomorrow.
everybody.
Thank you.
Bye.
Take care, guys.